Any other mentioning? Call the list, please.
Item on the list. Number 2. Tribunal of 935.
तो वाले मैं पता नहीं.
Yes, what is the matter about?
Lord, it is an challenging an order passed by the Central Administrative Tribunal, madam. But it consists of 5 volumes, not just.
Where is the order included?
Yes, ma'am.
Page number 19.
Retired in 2022.
Yes, my lord.
You are the appellant.
Yes, I am the respondent.
You are the respondent.
I am the original applicant.
Yes. Can we deal with it at the motion stage, or you want to come back upon exchange of affidavits?
My lord, all documents are, they have submitted. So nothing more, no documents are required to be annexed.
So no affidavits are required. Let us record that.
We are satisfied with what are the proceedings which is held before the Honorable Tribunal. We have filed by your 5 volumes. The other side has satisfied that all records are.
No records, additional records are required, my lord.
It can be taken, madam.
Yes, my lord.
Day after tomorrow.
Day after. Heard learned counsel for the parties. Learned counsel for the respondent submits that since all the relevant documents are part of the record, comma, exchange of affidavits is not required. Stop. The matter is ready for hearing. Paragraph, let the matter appear under the heading hearing on 30th,
Yes.
30th July.
Right, my lord.
Next.
Item number 3, Tribunal of 925.
Your Lordship, I am for the petitioner, Your Lordship. Paper book has already been filed.
Yes, madam. Lord, item number 3.
Who is appearing for the opposite party?
Lord, I am appearing for the respondents, madam. Lord, item number 3 and item number 6 are common matter, Lord. They have filed because 2 applicants have come before the tribunal on different okay. Both have been taken to trial and has been tribunal. Agreed by that order, they put an appeal.
So they can be disposed of by a common order.
Yes, yes.
Yes, yes.
3 and 5.
Yes, madam.
But in
I'm
part
sorry, madam. 3 and 6, madam.
6, Mr. Binu Kumar appears, I think.
Yes, yes. Same issues. 3 and 6, madam.
But it's a common order, you say?
Yes, madam.
Issue are same.
Same.
Orders are not common order.
Oh, they're separate orders, but the
Separate
issues are.
issues are.
So they can be together.
देखिए,
My lord, in item number 6, my senior appears for the petitioner. He, due to some personal difficulty, is not in station. I'm praying to fix it in the next week, madam.
let me start, your lordship. And it can be continued.
Let item number
Yes,
3.
my
be heard
matter
in
will
that
be-
case. Yes.
टैग नहीं कर रहे हैं अभी, मेरा मैटर देख रहे हैं। फाइल ओपन करो और वो हमको वो दिखाओ जिसमें जूनियर इंजीनियर का बोला गया, निकालो उसमें से, मालूम है? देख के नहीं।
Yes.
Case is that, your lordship, these petitioners, they are charge men.
They are.
Charge men. Your lordship, they wanted the pay scale of charge men. What the authorities are saying, that as you are not holding the diploma, that is, you are not holding the requisite qualification in terms of the pay commission report and as per the recruitment tool, you will not be entitled to get that pay scale of the charge man. No, your lordship, some persons, means the petitioners of another case, they initially approached this honorable court. This honorable court has passed an order directing the authorities to grant the set pay scale. However, those persons were holding the diploma. Now, your lordship, I'll just place that order. Your lordship will get an idea about this. What court निकाल? पुराना order. Your lordship, 171, page number 171. Note करके जाओ यहाँ पे. इंजीनियर का ढूंढो. Yes, Government of India का होता है. No, your lordship, I'm just placing it. None appears on behalf of respondent 1 and 2 even after service of copies of this writ application upon them by the petitioners. No accommodation is paid for. From the materials on records, it further appears that they never appeared before this court at the time of hearing of this matter. This writ application is filed by the petitioner assailing a judgment dated 27th August 2012, delivered by the Central Administrative Tribunal, Calcutta bench in OA number 182 AN 2010. By the impugned judgment, the above application of the petitioners was dismissed by the learned tribunal. The petitioners were working for gain in the post of Chargeman Electricity Department, Andaman and Nicobar Islands Administration. Fifth Central Pay Commission, constituted by the Government of India, submitted its recommendation in the month of January 1997. Clause 50.23 of the above recommendation at page number 138 of this writ application prescribed revision of scale of pay structure of engineering subordinate cadres possessing diploma in engineering. Now, your lordship, this is important. Now, we have carefully considered the demands of the Federation and the views of the administrative ministries departments in the light of our general approach on the pay scale of different professional technical groups of staff existing relativities between technical and non-technical categories. We have, as a general rule, decided to improve the initial requirement pay scale of diploma engineers in government. We accordingly recommend the following pay structure of engineering subordinate cadre. Now, your lordship, there is no dispute to the fact because this is an issue relating to chargemen only. So they are under the engineering subordinate cadre. There is no dispute to that fact. The Andaman and Nicobar administration took up the issue finalizing the left out case of granting the benefit of the above pay structure by virtue of a communication dated December 26, 2001 issued by Assistant Director Administration at page 43 of the application. Since no step was taken by the authorities to extend the above benefits in favor of the petitioners, they filed an application before the Central Administrative Tribunal, Calcutta bench at Port Blair, OA number this, and the same was disposed of on 12th April 2010 with a direction upon the respondent authorities to take a decision with regard to the above claim of the petitioners. The Andaman Nicobar administration in turn informed the petitioners by an order number this, dated this, that the above matter had been decided by the respondent number 1 before filing the above application by an order dated this, passed by the Under Secretary Government of India, Ministry of Power. The petitioners filed another application before the Central Administrative Tribunal, Calcutta bench, circuit at Port Blair, bearing OA number this, and after considering the grievance of the petitioners on merit, the learned tribunal dismissed the above application on 27th August 2012. Hence, this writ application. We have heard the counsel appearing for the respective parties carefully, and we have taken into consider facts and circumstances of this case. It is not disputed respondent number 1 rejected the claim of the petitioners on following grounds. The diploma in electrical mechanical engineering was not an essential qualification for the post of chargeman in electricity department as per recruitment rules. Number two, the educational qualification required for the post of chargeman in electricity department were lower than the post of chargeman in motor accident, transport department. These are two grounds on the basis of which it was rejected. Because in the electricity department, diploma in engineering was not the essential qualification for the post of chargeman. And then they have also said that educational qualification in the motor transport is different from the from electricity department. Taking into consideration the above grounds, the learned tribunal held that the decision-making process of respondent number 1 was legal and valid. After perusing the recommendation of the Central Pay Commission in respect of engineering subordinate cadres holding diploma in engineering, we find that the grounds shown in the order dated this were extraneous. There was no scope to take the aid of the aforesaid two grounds at the time of considering the claim of the employee engineers belonging to engineering subordinate cadres possessing diploma in engineering, and it was not in dispute that the petitioners fulfill these two criteria. Therefore, we hold that the impugned judgment cannot be sustained in a law because the decision-making process of respondent number 1 as communicated under communication dated this cannot be sustained in law. Necessary to point out that Andaman and Nicobar administration has sent a recommendation to the respondent number 1 in favor of the petitioners. It is true that there is a limited scope to issue a writ in the nature of mandamus for implementation of recommendation of the Pay Commission in course of judicial review. But after considering the decision-making process of Union of India, we find that the grounds for rejecting the claim of the petitioners are available from its decision dated this, and after considering the decision-making process of the above decision, a man of ordinary prudence has no other alternative but to hold that these were extraneous and the decision-making process was bad in law. We therefore quash and set aside the impugned order judgment dated this, delivered in this, as also the order of the respondent number 1 as communicated under memo dated December 17 December 2009. The respondents are directed to extend the benefit of the above recommendation of the Central 5th Central Pay Commission to the petitioners from the date as and when they become entitled to the same, that is including arrears. Now, these people, Your Lordship, they have been granted the pay scale. Thereafter, I'll just show the Your Lordship, thereafter, we have approached this tribunal. The tribunal dismissed our application and we have approached this honorable court, and this honorable court has passed an order, Your Lordship, that is important. Your Lordship may kindly come to High Court order. Just a minute. Look at 244, Your Lordship. Government of India order. अरे तो है हमको भागी इसमें है ओरिजिनल एप्लीकेशन का एक पेज निकाले और हमको दिखाते 244, Your Lordship. Here, when I approached the Central Administrative Tribunal, Central Administrative Tribunal rejected my application. Then I came before this honorable court. In the meantime, what happened? The government of India has taken a decision that so far as junior engineers are concerned, even if they are not diploma holder, they should get the higher pay scale. So our contention was that when you are able to extend the benefit to the junior engineer who are not in diploma holder, same benefit should be given to us also. Now, agitating that particular thing, Your Lordship, this honorable court has passed an order. Page number 244. May I place, Your Lordship? It's not a big one. ये वाला order 21/8/2008 and 14/2012 तो देखो कहाँ पे पेश कर रहे हैं Your Lordship, Your Lordship, shall I place entire thing, Your Lordship, from the
relevant part.
yes,
It was sent back on remand to the tribunal.
yes, Your Lordship.
The observations, the relevant.
That's what, Your Lordship. Page number 246, after going through.
Yes.
After going through the order of the superintending engineer, this court finds that the prayer of the petitioners for upgradation of pay scale of the post of chargeman in electricity department from 4,500 to 5,000 was rejected by placing reliance on the reply of the ministry video letter dated 17/12/2009 You have same letter which was issued by the ministry, which was the subject matter of the Honorable High Court. It appears therefore that the ministry observed a diploma in electrical mechanical engineering is an essential qualification for the post of chargeman in electricity department. After going through the recruitment rules published with a notification dated 12th December 1975, this court finds that a feeder post for promotion to chargeman is fitter. It further appears therefrom that the diploma in electrical mechanical engineering cannot be said to be an essential qualification in view of the expression or used in clause 2 under serial number 13 and 14. It further appears from the said recruitment rules that degree diploma in electrical mechanical engineering is an essential qualification for promotion to junior engineers. After going through the notification dated 21/8/2008, this court finds that Government of India, Ministry of Power, with a notification dated 21st August 2008, decided to grant upgraded pay scale of this to the non-diploma junior engineers. This I will show 21/8/2008. Engineer of the with effect from 1/1/1996. It further appears from the order impugned that a said notification was relied upon in course of hearing of the original application. However, the impugned order does not return any finding as to the applicability or otherwise of the said notification dated 21/8/2008. Record reveals that when Jivan Ram Lal was promoted to the post of chargeman from the post of LMMR, he was granted the revised scale of this plus this. This particular person was specifically granted this pay scale, though he is non-diploma holder. It further appears that office order number this dated 14/2/2012 was also part of the rejoinder filed by the original applicants before the tribunal. The impugned order does not take into consideration the fact that LMMRs were also granted the grade pay of 4,200 in spite of the fact that they did not possess diploma degree in engineering. Means you know the channel are different channels are there. From LMMR to chargeman is also there. From this lineman come meter reader. From that particular post, the promotion is also to the post of chargeman and it is also to the post of junior engineer. Now, this particular Jagjivan Ram was promoted to the post of chargeman from the post of lineman come meter reader. But he was holding the post of chargeman and he is non-diploma. He has been granted. They are saying that because it is from the different channel, that is the reason why he has been granted. That cannot be the reason because he is holding the post of chargeman and he is a non-diploma holder. Now, the fact that when Jagjivan Ram, who has since retired as chargeman of electricity department, was also granted the grade pay of this, in spite of the fact that he only had the qualification of having passed AI, SSE, and 2 years course of electrician from Model Training Institute, would be evident from the reply of the information sought for under the provisions of Right to Information Act 2005. It appears to this court that a similarly situated employee was granted the grade pay of 4,200 and the learned tribunal did not return any finding as to how the petitioner could have been denied similar benefit. Upon going through the notification of 21/8/2008, this court is of the prima facie view that the petitioners are entitled to the upgraded scale of pay of rupees this. We are also of the prima facie view that Jagjivan Lal, a similarly situated employee, was extended the grade pay of rupees this without having a diploma or degree in engineering. The order number this dated this also goes to support the case of the petitioners that they are entitled to grade pay of this even without possessing diploma or degree in engineering. The learned tribunal dismissed the original application on the ground that benefits of 5th Central Pay Commission cannot be extended to the petitioners as they are non-diploma holders. This court is of the prima facie view that upgraded scale of pay as paid by the petitioners could not have been rejected on the ground that they are non-diploma holders in view of the government order dated 21/8/2008 and the office order number this dated 14/2/2012. These aspects have not been gone into by the learned tribunal. For the reasons above aforesaid, we are of the considered view the tribunal should be directed to decide the matter afresh in the light of the observations and findings in this order. The impugned order is set aside. The original application is restored to the file of the learned tribunal, and the learned tribunal is directed to rehear the said original application upon giving an opportunity of hearing to the respective parties and pass a reasoned order in the light of the observation. I am not reading the rest of this. It has been remanded. Now, what the tribunal has done? Totally ignored everything and passed the order saying that the particular government of India's order is only specifically for junior engineer, so it cannot be granted. That particular thing has been looked into by the Honorable High Court. Very clearly it was said that it has to be extended because it has been extended to junior engineer. Prima facie view is there. How that prima facie view can be ignored by the learned, how it should be ignored, that discussion is not there in the order of the tribunal. I'm just placing you a relevant portion. It starts from page number 249, 14th February 2012 ka order. Now, Your Lordship, discussion has been made with regard to Jagjeevan Lal. Page number 258. It starts from 6.3.
Yes.
The said Jagjeevan Lal was initially appointed as a fitter in 1984. He completed 12 years of service in 1996. At that time, lineman cum meter reader was the feeder post of junior engineer, which carried a pay scale of this. Therefore, Jagjeevan Lal's pay was raised on the recommendation of a review DPC with a order dated this to rupees this with effect from 9/8/1999, along with the pay of some other LMRs, while granting him first financial upgradation under ACP scheme on completion of 12 years of service. In 2004, recruitment rules were notified and lineman cum meter reader became the feeder grade of chargeman. Since he was already in the pay scale of risk by virtue of financial upgradation under ACP scheme, on 1/1/2006, his grade pay was also fixed at rupees 4,200. Jagjeevan Lal was promoted as chargeman on 30th June 2007. Since he had already got the scale of rupees 8,000 by virtue of financial upgradation under ACP scheme, it continued to be the same even when he was promoted to chargeman due to pay protection, even though as per the recruitment rules, the post of chargeman had the grade pay of rupees 2,800. The case of Jagjeevan Lal and that of the applicants are distinguishable as they belong to different posts in their feeder cadre of LMR and fitter, respectively, which historically had different promotional avenues. Jagjeevan Lal was not granted the grade pay of rupees this due to his promotion as chargeman, since he was already in the pay of rupees 5,000, 8,000 by virtue of financial upgradation under MACP. He would have got the grade pay of rupees this even if he was not promoted as chargeman. The grant of grade pay of rupees this to Jagjeevan Lal was in the nature of pay protection and was personal to him. The applicants are therefore not similarly situated as Jagjeevan Lal and cannot claim similar benefits on the grounds of being similarly circumstanced as Jagjeevan Lal. This fact is obvious from the order dated 14/2/2012, which clearly mentions that the pay of Jagjeevan Lal has been fixed in the scale of this under ACP scheme with effect from 9/8/1999. That is when he was posted as an lineman cum meter reader. As per recruitment rules of chargeman, the post carries a grade pay of 2,800 per month. Applicants have been promoted as chargeman. Therefore, on promotion, they were rightly granted the grade pay of rupees 2,800. Now, Your Lordship, what discussion has been done with regard to Jagjeevan Lal and what the recruitment rule was there at that relevant point of time, I will just place it. The learned tribunal missed one important fact that so far as the promotion to the post of junior engineer is concerned, at that relevant point of time, the pay scale of junior engineer and the pay scale of the chargeman was almost exactly the same. I'll just show that. Now, the applicants in this POA and in subsequent submissions have attempted to establish their claim to grade pay of 4,002 on the basis of principle of equal pay for equal work. Pay or even pay scale of an employee in a particular post also depends on his service history, more specifically his position. And, Your Lordship, I'm just skipping this because these are not relevant. Equal pay for equal work will come later, Your Lordship. First of all, the Government of India's decision, which was in 2008, whether that has been taken into consideration or not, that is to be looked into. Now, Your Lordship, what I find, just a second. This is the decision, Your Lordship. I have gone through the entire thing. There is no discussion with regard to 21/8/2008 order of the Government of India. No discussion is there. The Honorable High Court specifically said that the Government of India's order dated that has to be looked into because if it is subordinate engineering cadres. Now, subordinate engineering cadre includes chargemen as well as junior engineer. You have taken a decision, Pay Commission's recommendation was there that subordinate engineering cadre has to be given a particular pay scale. Now, you have decided that diploma holders should be given. For junior engineer also diploma holder, for chargeman also diploma holder. You extended the pay scale. This Honorable Court has held that it should be given. Now, Government of India has taken a decision in 2008 that even non-diploma holder of junior engineer should be granted. Why that particular decision of the Government of India cannot be extended to the petitioner here?
Where is the Government of India?
Yes, page number 14. Page number 142. May I place, your lordship?
Yes.
I am directed to refer to the Andaman and Nicobar Administration letter number this, dated this, and letter number this, dated this, on the above subject, and to say that the proposal of the administration regarding upgradation of scale of pay of non-diploma holder junior engineers in the electricity department from pay to this has been reconsidered in this ministry in consultation with the Ministry of Finance Department of Expenditure. It has been decided to grant the upgraded scale of pay of rupees this to the non-diploma holder junior engineer with of the Electricity Department of Administration with effect from 1/1/1996. This issues with the approval of the Ministry of Finance. This is this. Further, the Honorable CAT may be apprised of this decision with reference to its order dated in the original application Joseph D'Souza versus in some of the cases it was decided. No, your lordship, my position is almost exactly the
So
same.
this order of the CAT pertain to junior engineers,
Yes.
Not
the last paragraph.
this is some other case. Some other case, not in my case. Maybe some non-diploma holders or junior engineer, they have approached the tribunal.
Yes, that's what I'm saying.
Yes, your
Yes.
lordship. And so the ministry has taken a decision that even to non-diploma junior engineers, it should be granted. So when the ministry has taken a decision with regard to one of the subordinate cadre of engineering, then why that particular decision should not be applied in my case? This is what the decision of this honorable court in the earlier round of litigation. The honorable high court specifically observed that they are same subordinate cadres. So prima facie view was there that it should be extended to the petitioners also. The tribunal totally overlooked that thing and dismissed my application in lordship.
That's
This
what
is,
is-
yeah, this is basically my case. And recruitment rules also I can show it. But if your lordship, they are able to satisfy this particular point, then I will show the recruitment rule. That even the junior engineer pay scale and the chargeman pay scale, your lordship, at that relevant point of initial days were almost the same. That also I will show.
Yes,
My lord, there are two aspects, my lord. They are claiming that the Jagjeevan Lal would to be as a fitter and he has become promoted as a chargeman and he has got the pay scale of 5,000 to 8,000 with regard to the fifth pay benefit. So why that should not be extended to this? This honorable court has said as a prima facie view, when you are giving to that particular settlement, why that cannot be extended to the applicants? This is the first, my lord. The second aspect is the government of India 2008, whereby they have made an observation that it should be granted to the non-diploma holder junior engineers. Lord, there are two aspects over this instant case. The first aspect is that not the persons, those who have initially come before lordships before this honorable court claiming that they should be granted with the fifth pay commission benefit, as they have been diploma holders. There were differentiation have been given with the diploma holders and non-diploma holders. This honorable court said the diploma holder should be granted with the pay scale in terms of the 50.20, the recommendation of CP3. That has been done, my lord. My lord, the persons, those who are under earlier recruitment rule, it was LLMR being the feeder post to be promoted to the post of junior engineer. If a person who has to be promoted from LMR to junior engineer, because he is become as non-diploma because he don't have any diploma, so he has not granted with the pay scale. Subsequently, it has been clarified by the ministry because if a person who is junior engineer as a LLMR is a feeder post, junior engineer is attained the post of junior engineer as a promotion, he will not be granted with the pay scale of the those junior engineers who are having a diploma holder. So the ministry has clarified that the non-diploma holders, those who are junior engineer, should be granted. That is the 2008, my lord. With regard to Jagjeevan, my lord, he has been promoted from LLMR to chargeman. At the time, Jay, thereafter, he has
it was decided that the junior engineers without a diploma will also be granted.
granted, my lord, subject to that Jagjeevan Lal become as he is an ACP. He has not been granted with the pay scale. Under the pay scale has not been, the benefit of pay upgradation has not been granted to him. He was, as a LLMR, he was promoted to post of junior engineer because he has non-diploma holder. Feeder post was, LLMR was a feeder post at that point of time. So he has been promoted to the post of junior engineer. So when he has been granted, not granted to the post of junior engineer pay scale, so ultimately, as per the Government of India 2008 OM, he should be granted with the pay ACP, and the ACP has been granted, he has been upgraded with the pay scale. So as such, when he has come to the chargeman, so 4,200 he has been granted the pay scale due to already he has been upgraded on the ACP. That is because it was granted on a promotion ACP scheme, not as a pay upgradation. He has not get. These are the two aspects which was decided by the tribunal. You may not make kindly come to page number 254. 254. May I read, my lord?
254?
250, the
Yes.
impugned order in question, my lord.
Yes, yes.
Para 5. The respondent, on other hand, reiterated the stand taken in the reply as was during the earlier hearing. Learned counsel for the respondent has filed a written notes of argument elaborating a reply in the OA filed by the respondent and respondents earlier. In addition, in the written notes of argument, the learned counsel for respondent submitted that Jagdivan Lal was initially appointed as a lineman cum meter reader on temporary basis in pay scale of so and so wide within order number 325 dated 3/6/1984. As per the recommendation of the anomaly committee, Andamani Committee, his pay was upgraded to the scale of pay of 4,600 with effect from 1/1. He was granted first ACP benefit, order dated 27/4/2010. His pay was fixed at 4,500 to 7,000. That is the pay scale for the next promotion, post of lineman cum meter reader as it exists in 2010. His financial upgradation was given with effect from 9/8/1999 when he had completed 12 years of service on the promotion to the post of chargeman on 30/6/2007. He is continuing the pay scale of 4,000 to 7,000, which was initially a grade pay for the post of chargeman. However, in 2002, following the recommendation of review committee, ACP benefit granted to Jagjivan Lal and some other LMRs were revised wide order dated 14/2/2000 on the ground that at the time when Jagjivan Lal completed 12 years of service in 1999, next promotion post of lineman cum meter reader was junior engineer. Since the junior engineer post as per the order dated 21/8/2000 carried a pay scale of 5,000 8,000. Jagjivan Lal first upgradation ought to have been to the scale of 5,000 8,000. He was therefore granted the scale of rupees 5,000 8,000 as a result of financial upgradation under the ACP scheme. Subsequently, in 2004, next promotional post of lineman cum meter reader was changed to chargeman. Jagjivan Lal was promoted to the post of chargeman in 2007. Since his pay ought to have not been a pay scale of 5,000 8,000, which was higher than the pay scale attached to the post of chargeman 4,000 to 7,000, his pay was protected as per the rules and benefits purely personal to him as per the Government of India's letter dated 21/8/2008. The upgradation scale of 5,000 8,000 admission only to non-diploma holder junior engineers of electricity and not to the chargeman. Thus, it is clearly from the opposite order number 299 dated 4/2/2012 and the grade pay of 4,200 has been granted to Jagjivan Lal by virtue of first financial upgradation under ACP scheme. It cannot be treated as a pay scale of chargeman as first ACP in the pay scale of 5,800 has been granted to him with effect from 9/8/1999. Jagjivan Lal was promoted to the post of chargeman on ad hoc in the pay scale of 4,070 since 2007 and subsequently regularized on 2/6/2006. The order of 4/2/2012, his pay was fixed 5,000 to 8,000 with effect from the scale continued to be pay protection when he was promoted to the post of chargeman in 2007. Now, the tribunal has taken both the notes which has been directed by this honorable court with regard to 2008 and with regard to the Jagjivan Lal. It has been decided in 2008.
Yeah.
That is
The notification.
yes, my lord. 21 August
That is
2008.
not discussed anywhere
My lord,
in the tribunal's order.
my lord, I can show the recruitment rule of the earlier one, my lord, where the LLMR is the feeder post.
Jagjivan Lal case and that the
Let
other
him
thing.
complete,
Yes,
you'll get your chance.
you know,
My lord, the tribunal, while considering this aspect, as the learned senior counsel has already read the entire judgment, my lord, I will not trouble this honorable court to that extent. My lord has already the differentiation with regard to Jagjivan Lal and the orders which has been passed by the government, how it has to be affected to the person, those who are before your lordships. My lord, this before lordships, they have been promoted from fitter to chargeman. Their initial appointment, they are 10th standard pass and having an ITS certificate. And the earlier it was diploma holder, as subsequently when the ministry said when you are being given to non-diploma holder also to junior engineer, my lord, that has been differentiated. They are not junior engineers, they have been chargemen. And the chargeman pay scale at present, my lord, that is 2,800. If my lord will see the pay structures which cannot be jumped into from 2,400 to 4,200, my lord, because there are the slabs which has to be completed. So 2,400, thereafter 2,800.
Earlier slab of the junior engineers.
My lord, my comment. Earlier, my lord, old recruitment rule, my lord.
No,
The
now
2010
they are
recruitment?
doing- Yes, the last rules.
Yes, yes.
When prior to their promotion as junior engineers, what was their pay scale?
Lord, they are fitters, my lord. They are fitter. They are fitter from fitter to chargeman.
chargeman is also fitter, junior engineers were also fitters, right?
No, no, my lord. My lord, there are two aspects, my lord. Earlier, the recruitment rule, a person who is holding the post of lineman come meter reader, he has to become on the same manner as a 10th standard pass and thereafter ITS certificate. But the RR says he should be as a feeder grade to be promoted to the post of junior engineer. The pay scale was recommendation specifically for the diploma holders. And the persons who have been promoted to the, because they have not a qualification, they cannot be granted with the junior engineer post. They have to be at the most, they can get the ACP or to the pay benefit up to the promotional post. So they have been the Jagjeevan lineman cum meter reader. So he has been promoted as a, he cannot be promoted because he don't have a qualification. So he has been granted the first ACP benefit, that is at par equivalent to the pay scale of junior engineer. So he has got
So
it.
that pay following, he
Yes,
was
yes.
already there when he was promoted.
Yes, my
He
lord.
was already holding the same, that pay scale when he was.
Yeah,
promoted.
yes. So
Yes.
he
So
as
he
per
continued
after
with
2010, when the recruitment rule was amended, so the fitter should be promoted from fitter to chargeman. The pay scale of fitter is 2,400 grade pay and 2,800 grade pay. So the at present also the grade pay of the chargeman is 2,800, and the same it is not been amended or not been upgraded. So the only contention is when a person who is holding a non-diploma who has to be similarly situated as we are also having the same qualification, when you are granted that person a pay scale, why not that benefit should be extended to us? So this is the only contention of the
Yes.
applicant before a lordship, my lord. Not so far as I mean to say, my lord, because the pay benefits, it is an expert body they have to consider, my lord, because it is now they are coming for upgradation of the pay from 2,800 to 4,200. But my lord, kindly consider the facts. The authorities have never gone into anything wrong, because what I say is, my lord, the 2,800 grade pay, it was still exists. And the qualification prescribed over the recruitment rule of fitter grade is 10th standard pass and having ITS certificate. And he can be promoted to the chargeman. My lord, with regard to that aspect, that Jagjeevan Lal, I'm repeating, my lord, I'm sorry, my lord, I'm repeating again and again, that Jagjeevan Lal. Yes, my lord. Yes, my lord. The
We
2008,
are on this junior engineers and the chargemen.
no, the chargeman, the persons those who are holding junior engineer, at the time the junior engineer person feeder post is LLMR. If I am being an LLMR, I have to be promoted to the post of junior engineer if I am having a diploma. If I am not having diploma, then I am entitled to get the pay benefit of junior engineer. So as such, the authorities clarified to the ministry, we have two sorts of people. One is junior engineer, one is the person who are holding LLMR and cannot be accommodated with the pay scale of junior engineer. So the ministry in 2008 clarified that a person who is not having no diploma holder, he should be granted with the pay benefit of their upgraded scale. So in that criteria, and SEP has been granted to Jagjeevan Lal, he has been granted the pay scale. So these are the two aspects. So the applicants are not similarly situated persons with regard to that claim has been made before lordship. This is my respectful submission.
Yes,
Your Lordship, in reply, Your Lordship, I am just submitting that this particular aspect of 21st August 2008, that decision of the Government of India, that was already looked into by this Honorable Court. And this Honorable Court was of the prima facie view that, because now at this stage, Your Lordship, we cannot ignore the decision of the Honorable High Court. Let him show, Your Lordship, that at anywhere the tribunal has discussed that particular, anywhere. Because there is a direction of this Honorable Court that this aspect, Jagjeevan Lal, I can understand, Your Lordship, that discussion has been made. No issues with regard to that. However, Your Lordship, and the recruitment rule, so far as lineman cum meter reader is concerned and the fitter is concerned, the pay scale is almost the same. Fitter, and one channel is from fitter to chargeman, and that also included lineman also. Your Lordship, if Your Lordship will come to page number 196. 197. Your Lordship may kindly come to 197.
one 197, yes.
197. Now, Your Lordship may kindly see serial number 14. Now, here, Your Lordship may kindly see promotion from among linemen. Serial number 14 is a chargeman electrical. Promotion from among linemen / assistant linemen / fitter electrical with 15 years experience in the trade and passing departmental tests prescribed from time to time. Now, Your Lordship may kindly see the junior engineer. Serial number 12, 196.
Yes.
Now, your lordship, may I see promotion from lineman come meter reader, oblique meter tester, having service for a period of not less than 8 years in the electricity department in the grade. That is the only qualification. And if we see that, just a minute, your lordship.
Degree or diploma holder. Non-diploma is
And when these people are promoted, they are non-diploma holders. Because their qualification, as prescribed herein, lineman cum meter header, serial number 9, your lordship may kindly see SSLC/matriculation with trade test certificate from a recognized institute. That's it. Diploma is not required. So when these people are getting promoted to the post of junior engineer, because their diploma is not attached. While giving promotion, the requisite thing is that trade certificate and 8 years service. That's it. So these people are getting promotion to the post of junior engineer and they are non-diploma.
So their service period is, they are qualifying with regard to the service period.
Yes, 8
They
years.
have more than 8 years service.
Yes. There is no dispute. As per the qualification prescribed in the recruitment rule, those people have been promoted to the post of junior engineer. There is no doubt about it.
It's only the scale.
Only the qualification of diploma and non-diploma, your lordship. There was no requirement for diploma and degree in engineering for promotion from the post of fitter to junior engineer, lineman from to junior engineer, as per the recruitment rule. No requirement. So,
What does that mean? For promotion to junior engineers, no diploma is required.
yes,
That is not
non-diploma.
in dispute.
That as per earlier recruitment, thereafter it was amended, it was been removed.
That is
After
a
the
different
LLM was been.
We are
taken
not concerned with that now. Afterwards,
When
what
it
happened?
was
It's not
earlier-
immaterial.
The only issue which stands now is that you say that you are at par with the junior engineer.
Yes, your lordship, because in the same department, in the same engineering subcadre, you are considering, the government of India has considered one set of individuals and granted the pay scale. The main reason is that, your lordship, the junior engineer who are diploma holder, junior engineer who are non-diploma holder are discharging the same duties. They are not doing some different duties. Say, like us only. Chargemen who are diploma holder, chargemen who are non-diploma holder are discharging the
Are
same
the
duties.
chargemen and the junior engineers discharging the same duties?
No, your lordship. But they are falling under the same engineering subcadre, subordinate cadre. That is what the Honorable High Court has observed. That they are falling under the same subordinate engineering cadre. Now, if you are considering for one set of individuals, why these people should be ignored? So, specific direction has been given to the tribunal. You consider this aspect. The tribunal did not even.
Because with Jagjivan Lal, I don't think.
No,
it
Your
was
Worship.
able
I
to-
am not arguing at all. I am not arguing. I am just placing, I have placed the Honorable High Court's order, and my whole contention is with regard to the Government of India's decision in respect of junior engineer non-diploma holders. Complete. And I have just shown you also the qualification criteria. That qualification criteria, also, even for Jeevan Ram also, he is also non-diploma. When he got promotion to the post of junior engineer, at that relevant point of time, the scale of junior engineer got increased.
He was already enjoying it when he was in the earlier post.
No, Your Worship. When he got the ACP.
He got the ACP.
ACP. Now, when he
See,
got
even before he was promoted to the post of a junior engineer, he was
he
enjoying
was
the.
promoted to the post of
Not
junior
having
engineer.
qualification also, even
Oh,
with the
that's
promotion
Even
scale.
the ACP.
Yes.
He was given the ACP of the scale of junior engineer. Now, what happened, Your Lordship? The scale of junior engineer, diploma and non-diploma, both was actually became one when he got the promotion. At that relevant point of time, as these people, Your Lordship, just kindly consider this aspect, what I am submitting. In 2008 only, the government of India took a decision that non-diploma should get the same. 2008. Then, why Jagjivan Ram has been given the scale of junior engineer diploma holder by way of ACP in 1999. Why he was given? He should have given non-diploma only, but he was given the diploma, this thing. This was actually the fact. What I wanted to argue before the tribunal at that relevant point of time is this, that in 1999, you had two set of people, junior engineer non-diploma, junior engineer diploma. And junior engineer non-diploma were getting lesser pay scale than the diploma. That is what the decision of the government of India is also there. Then Jagjeevan Ram, who was a non-diploma holder, why did you give the higher pay scale to him of junior engineer diploma holder? There is no answer to that. If we look into that criteria, Your Lordship, the Jagjeevan Ram has been given ACP, everything looks very fine. But if we look into the actual thing, what has happened there, because Government of India order clears the fact that junior engineer diploma holder and junior engineer non-diploma holder were getting different pay scale. That is very clear, Your Lordship, up to 2008.
They were at par from 2008.
Yes. Then after 2008, they were getting same.
But this happened prior to that.
This happened in 1999 itself. You have given that pay scale to Jagjeevan Ram, higher pay scale of why? So there is a clear discrimination. That is what the Honorable High Court also looked into, that it appears to be a discrimination. So my submission is that, Your Lordship, when they are following in the same engineering cadre, so the benefits we are discharged, we have not been given a different duties than that of the chargemen who are holding the diploma. We are also discharging the same duty in the same department. So I pray, Your Lordship, that benefit may be given.
Yes, that's all.
Yes, my lord.
It is
As I
okay.
clarified that Jagjeevan Lal and the OM.
Yes. Jagjeevan Lal was given prior to 2008.
Yes.
Yes.
The bar between diplomatic and non-diplomatic was raised only by the notification of 2008.
Yes.
But he was granted the
99.
benefit of diplomatic
First ACP.
having holding a diploma prior to,
Yes, ma'am.
though he was not holding a diploma.
Diploma.
How do you explain that?
No, that's why, ma'am. My lord, may kindly come to page number 197, my lord.
Yes.
इसका स्केल ऑफ पे का पूरा डिटेल है मेरे पास में.
Not the
Yes.
left hand side, it is given as serial number 14 as my
Yes.
senior counsel has pointed out, my lord.
This is of 1986.
My lord, the column number 11.
Serial number 11,
Yes, my lord, serial number that is 197,
197.
column number
Oh,
11.
Yes. Yes.
If my lord will see, at that point of time also, my lord, if we see, my lord, the promotion from amongst lineman, assistant, lineman, fitter, electrical with 15 years service on a trade. If a person who has to be promoted to the chargeman, he should be holding it, the lineman, assistant, fitter, electrical with its 15 years service in the trade. My lord, this also prevails today also, my lord. I can show it from the today recruitment rule also. My lord, may kindly come to the junior engineer.
Serial number 12.
Yes.
Yes, my lord. My lord, page number 196, my lord.
Yes. serial
Column
12.
number 11, my lord. Promotion from lineman come meter reader, testing having service for a period of not less than 8 years in the electricity department in the.
This says degree or diploma.
Not because a person who is a lineman come meter reader, he is also not having at the time regarding 10th standard, he is not having any diploma. So he should be promoted if he has 8 years in the grade. Then he should be promoted to be as a junior engineer. If he has a diploma, then he will be granted with the junior engineer. If he is not having a qualification, then the pay benefit has to be extended.
The pay benefit of without diploma has to be extended.
Yes, my lord, that's
Not a. with
Right,
diploma
absolutely
pay
right,
benefit.
Lord,
But you have
absolutely right.
extended a with diploma pay benefit.
Yes.
to him.
because he has been granted with
1999.
1990, because he is to be treated at par with the junior engineer pay scale.
Junior engineer without diploma.
Right, my lord?
You have granted the with diploma pay scale.
My lord, with
Because in
diploma.
1999, there was a differentiation,
Yes, my lord.
with and without.
Yes, my lord.
You granted the with diploma, though he didn't have a diploma.
That's why, my lord, I'm saying, my lord, because he cannot be promoted to the post of junior engineer as he don't have any qualification of diploma. So if we are to treat at par with the persons who's already been amongst him or who having a diploma holder who have been promoted to junior engineer, he should be granted with the pay scale of the junior engineer. Because that should be balance has to be maintained, not because he is to be feeder grade. The junior engineer feeder grade is lineman cum meter reader.
Yes.
If a person is holding lineman cum meter reader post and he is having no qualification of diploma, then he should be granted with the pay benefits.
It has come to 142.
Yes, ma'am.
Document order of 2008.
Yes, ma'am.
So see, there are non-diploma holder junior engineers and diploma holder junior
Yes.
engineers. So he ought to have been granted, even in ACP,
Yes.
he ought to have been granted the non-diploma holder junior engineer scale,
Yes.
not the diploma holder's junior engineer scale. You have granted him the diploma holder junior engineers.
No, my lord. My lord, it has been last.
Junior engineers have there were two divisions, right? Diploma holders and non-diploma holders. So Jagjeevan should have been granted.
No, there are, because junior engineer, those who are having diploma holder, he will hold the post of junior engineer. But the person who has to be non-diploma holder junior engineers, because it has to be promoted, those who have been non-diploma junior, they should also granted with the pay scale. That was the communication of ministry.
That was
No.
in 2008.
Yes.
Prior to that,
Well,
there were
after
different pay
2008,
scales for
he has been
non-diploma
revised.
Diploma.
My lord, I come to the minutes of meeting of the Jagjeevan Lal, my lord, it will be clear, because it has been done based on the revision after this. My lord, we kindly come to page
So
number
he was granted
214.
prior to this.
Yes, yes, my lord. My lord, we kindly come to page number 214, my lord. The minutes of meeting for review of first ACP scheme to lineman cum meter reader.
Yes.
My lord, the issues related to grant of ACP to lineman cum meter reader appointed directly meter reader and redesignated as lineman cum meter reader with effect from 1/10/1996. The department appointed lineman cum meter reader from time to time, smooth functioning of the prior to fourth pay commission. Pay scale of lineman cum meter reader and meter reader was a pay scale of so and so plus other allowances as administered. The pay scale was revised so and so for the above category in implementation of fifth pay commission. The anomaly committee suggested that the upgraded scale of pay as notified may be extended to lineman cum meter reader in the pay scale of so and so. The committee recommended that the upgraded pay scale of 4,600 may be granted to the lineman cum meter reader and meter reader. As per the direction of admission, the post of meter reader was de-designation as lineman cum meter reader in the pay scale of 4,000 dash 100 dash 6,000 with effect from 1/1/96, and they were brought on to the equal status of lineman cum meter reader with equal pay. Prior for redesignation, the pay scale of lineman cum meter reader was same and there was no difference of pay between these two categories. But while granting ACP, the grant of appointment of meter reader redesignated to the post of lineman cum meter reader was considered from the date of redesignation and not from the date of initial appointment. On redesignation, there were no financial upgrades. Therefore, some of the meter reader were designated as lineman cum meter reader adversely affected. The following meter reader who are victims as listed below. Not they given the names. The above employees were eligible for benefit of ACP on completion of 12 years of service in the cadre from the date of, but they have not allowed ACP from the date of redesignation of the
Here
post.
you've not considered the diploma, non-diploma part.
Yes, my lord,
There's
that is my submission.
explanation as to why this scale was given.
No, we say that as it was the feeder post at the earlier time, so he should be considered. That's why the DPC has been convened and they granted with the pay scale. And
This
the reason has been given, my lord, the following, that third paragraph, my lord.
This is in 2012. So
After 2008. Yes, my lord, after 2008.
Benefit has been given from 9/8/1999.
With effect from 9/9, because ACP has to be from after completing 12 years.
From 9/8/1999 to 2008, they should have been given the non-diploma, and 2008 decision has been taken. After 2008, that upgraded should be given. If that 21/8/2008 is implemented, But you have given the upgraded scale from 9/8/1999. Order is page number 217.
Lord, the persons who was entitled to be granted with the ACPs after qualifying 12 years of service. He was qualified from 1999. So already the scale which has to be granted, it has to be, the ACP has to be granted.
Directly granted the diploma scale.
Yes.
As per the
Which
minutes.
came into effect in 2008.
8.
My lord, that is after
So
DPC
prior
has
to that-
convened 2012 and they have been extended that benefit to the non-diploma holders.
Yes, it was in 2012. But from 1999 to 2008, till the notification was issued, he should have been given the non-diploma.
Non-diploma.
Lord,
Non-diploma.
he was.
No.
That's why, my lord, after
2017
DPC has been convened,
is
after
that?
DPC. My lord,
No,
after
let him check.
DPC has been convened, thereafter only he has been upgraded with that pay scale, my lord.
From
Prior
99.
to that, it was not done.
From 99.
After
Effect
2008.
From 1999.
Yes, my lord, because the ACP due is,
In 2012,
my lord,
he
right.
completed 12 years in 99,
Yes, my lord.
right? So you
Because
give
as he has to
effect
be-
from 99, yes?
My lord, is,
But from 99 to 2008, he was not entitled to the diploma scale.
my lord, he was not granted at the time. My lord, kindly, my lord, the ACP, if he is qualified to be 12 years of complete service. He is to be qualified in 1999. As per 2008 OM, it is granted to non-diploma. Then DPC, review DPC, my lord, that is a DPC was convened, review DPC. Earlier he was not granted. After review DPC has been convened, in terms of the 2008 OM, thereafter only they have been granted.
From
That's why the review DPC, my lord.
No dispute.
Yes.
But from 1999, he could not have been granted the diploma scale.
My lord, but he is entitled from 1999, my lord, because as per the
He is entitled to the non-diploma scale till 2008 because there was a differentiation between the diploma and the non-diploma scale.
yes, my lord.
From 2008, they were merged.
Yes, my lord.
So from 2008, he's entitled. No
Yes,
dispute.
yes.
What about 99 to
No, I,
2008?
again, I'm saying, my lord.
You have
I'm-
given him effect from 1999 because he completed 12 years, fine.
Yes, my lord, because he
But
has
you
been.
give the diploma scale to him, you should have given the non-diploma
No,
scale.
my lord, we have given that he was not been granted with upgraded scale from 99 to 2008.
What is
Thereafter, when review DPC has been convened in terms of the
Is
2008.
it a retrospective notification?
No, pay benefit.
2000
When he has become entitled, he has to be granted, my lord. That is the
prospect?
principle, my lord, because
It's a prospective notification.
And 2017 page number.
my lord,
election
when
2019?
2008, when the 2008, no,
Let us see the notification.
Yes, your lordship. Same क्या page number था?
With effect from 1196. That's all.
that's,
We'll reserve it.
yes.
With effect from 1196.
It has been decided to grant upgraded pay of this to the non-diploma holder, junior engineer with effect from 1199.
So he was.
So he was given.
He
Your
was
lordship.
there. So this part goes.
This part
It is
goes, your
only
lordship.
the junior.
Because even I felt, your lordship, that
Yes.
why he has been given.
Yes, yes.
So by
So
implementing
we'll
this,
reserve this.
your lordship, my only argument with regard to engineering category, your lordship.
Argument concluded, judgment reserved.
Not this item 6 also same fitter is fitter.
But I think.
The other side is ready, then the same mode of argument, same facts, my lord.
senior
Everything
effect
is.
Not there.
Yes,
Let us
I'm
not
sorry.
advance.
I'm sorry.
Let us-
Your lordship.
come back. Next week, Monday? Monday. This is item 6, right?
Yes, yes, my lord. Item 6,
Uh,
same sort of employees, there are 5,
Let's take an order in item.
is a
number
6th employee.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on Mondays. Mondays, 4th August, I believe. 4th August.
Your lordship.
Blair.
Obliged.
Yes.
Item 4, WPCT 15 of 2025.
But the other side advocate has informed me that he won't be able to appear today. So, my lord, that this matter will not fix from 7th or 8th, my lord.
That's close to the end of the circuit.
My lord,
Stop
they
at
have
it
informed
earlier.
me that their person is there, the private respondent.
This week he'll not be there.
No, he appears from, against from Calcutta.
Tirnavkars.
Yes, the lawyer requested me, my lord, to take time. From Calcutta is coming from Calcutta.
When is he coming?
7th.
Just start 2 more days after that. How can we take up a matter? He's not coming prior to that. He can join virtually. He can join virtually. Very well.
Six. I'm good.
Learned counsel for the petitioner,
Respondent.
for the respondent seeks accommodation. Let the matter appear under the same heading on 6th August.
I'm good.
Next.
Item 5, WPCT 16 of 2025.
And my senior appears for the petitioner. Can it be in Monday?
Very well. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 4th August.
My lord, obliged.
Item 7, WPCT 18 of 2025.
My lord, I am appearing on behalf of Mr. Singh as he is not feeling well today. We have received a supplementary affidavit from them. However, we are not filing any reply. So we request you to please carry forward with hearing, possibly on Wednesday or Thursday.
Tomorrow.
My senior is not feeling well. If we could give a day's time, day after.
Day after.
Day after.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on day after is 30th, right?
Yes, ma'am.
30th July.
I have.
Next.
Item 8, WPCT 30 of 2025. Item 8, WPCT 30 of 2025.
Anyone for the petitioner? None appears for the petitioner. No accommodation is sought. Let the matter appear under the same tomorrow. Let me fix it tomorrow. Let the matter appear under the same heading on 29th July.
Well, I am appearing for the petitioner in it.
Which matter?
Item number 8.
Yes.
Not.
You are ready?
Yes.
Please strike that out. Paper book prepared.
No, not required, my lord. I enclosed everything.
You have annexed all the documents?
Yes, yes.
Very well. Yes.
Well, it was dismissed on the first day itself. By holding that, the connected matter is pending before the Honorable Apex Court. My lord, kindly come to the impugned order.
So has the Honorable Apex Court decided the issue?
No, my lord. Actually, my lord, this issue is, in particular, it is not pending.
But a similar issue is pending, I think.
They say that similar, but it is not similar, according to me. My lord, my case is that, my lord,
In that case, we need to look into the issue pending before the Honorable Supreme.
I am not party to the proceeding. I don't have anything, my lord. They can produce the documents.
Yes, you say that
We
it's a similar, same issue?
Yes, yes, sir. Because it will ultimately affect if,
No, I am not party to the proceeding before the Honorable Apex Court.
no, we can produce that details, sir. Let it be.
No, if you say that it's the same issue pending before the Honorable Supreme Court, then we need to adjourn the matter.
It
When
is
is
not
the-
same. It is not same.
When is the date before the Honorable Supreme?
Let it not today, my lord, we take the.
Leave was granted, my lord, on 15/11/2019.
No, my lord, the same matter.
No, it's not same.
Pending before the Supreme Court, not, the party is different. But, my lord,
The issue is the same.
issue
you
is
say.
the same, because what has happened is that some police persons have went to the CAT. They seek that they should be promoted. So CAT has allowed their application. We went to High Court also allowed their application. Supreme Court stay has been granted. But that matter is pending before the Supreme.
And what is the present issue?
And present issue is that the persons who are promoted, they're seeking further promotion. So their current promotion is uncertain, so how can we make them give further
So unless
promotion?
that is decided, I don't think.
No,
we
it
can
is
decide.
not connected, my lord.
And there is already an order of a coordinate bench, I find that
My lord.
the matter is pending, so let it appear before the next circuit.
I say respectfully, my lord, this is not similar to that of the matters pending in Supreme Court.
You are not appearing in that matter, sir, before the Supreme Court.
My lord, they are making only oral submission. Let the document be produced. I am not party to the proceeding before the
We
Honorable
can
Apex
file
Court.
this document on affidavit, we can file it.
Let them file the affidavit so that I can also understand.
So let us adjourn it
Yes.
for this circuit. Let them come back with the affidavit in the meantime.
My lord, it may fixed after 10 days, my lord, if it is possible. 10 days, they can file the short affidavit saying that enclosing the document.
We will do that.
Oh, very well. Let it be on next Monday.
Yes.
My-
Next Monday,
Well,
learned counsel for the respondents submits that a special leave petition within bracket civil pertaining to the same issue as in the present application is pending before the Honorable Supreme Court. Learned counsel seeks to submit an affidavit annexing the relevant documents which would prima facie suggest that the same issue is pending before the Honorable Court. Paragraph, let the matter appear under the same heading on Monday's 4th
I'm deeply obliged.
August. Next.
Item 9, affirmative 2 of 2025.
सबको तो सर्विस नहीं है।
Yes, item 9.
Yes, Your Lordship. I have served, Your Lordship, all the respondents. This is also a ready matter, Your Lordship.
Who is appearing for the
My
respondent?
lord, I used to appear in the Leonard court below. Yesterday in evening, I called my clients. There are number of persons are there. Only few has received the notice, not
Yes,
everyone.
sent, Your Lordship,
Your
to
affidavit
everybody.
of service?
Yes, I have filed it.
Only को बुलाओ।
2, 3 and 7 has been appearing. You are appearing for 2, 3 and 7,
Well-
right?
All are related, Your Lordship, brothers and sisters.
ये नहीं बोलता अंजलि। इनमें तो क्या
भेजा है सर।
फिर रिसीव किया होगा? वो तो देखना
पोस्ट
पड़ेगा।
पे भेज दिया है, रिटर्न तो कुछ आता नहीं था वहाँ पर। इंडिया पोस्ट का हालत ऐसे ही बुरा है।
तो वो देखना पड़ेगा ना, रिसीव किया कि नहीं किया।
किसी का आजकल मिलता ही नहीं है, ट्रैक रिपोर्ट ही नहीं मिलता।
It is to be seen whether they received, my lord.
Your Lordship, I have
Notice.
sent, Your Lordship, sufficient time has expired. We have not received any refusal or something like that. Now, after the amendment of CPC, Your Lordship, it is to be presumed that it has been served.
Where is the track report?
Your Lordship.
Track report?
Track report, Your Lordship, really we are not getting it.
7 defendant respondents are there. You need to submit the track report
Your Lordship, I will.
to show that it has been served.
Your Lordship,
When can you come back?
I will come back tomorrow with the day after tomorrow, Your Lordship.
7.
Moreover, Your Lordship, 2, 3 and 7. Your Lordship, one thing is to be noted because this is a matter which has been remanded by the Honorable District Judge to the Civil Justice Senior Division. My learned friend and Miss Dolly Shah, both of them have been appearing for all the defendants. So they can inform the defendants, Your Lordship.
We informed, my lord, at the first instant I submitted that. Yesterday I called them, saying that matter is fixed today.
I will give
They
a
say that
you-
we have not received the copy.
give a copy.
Since you are representing all of them, why don't you receive a copy?
I will give a copy. I
Yeah,
will give
but,
copies of all.
That will save time. We
At
can
the same
keep
time,
a
you
copy.
don't get any material instruction, my lord, that is all difficulty. If they received the notice, then it is okay. Otherwise, it is very difficult.
Please come back with the draft.
Day after tomorrow. I will try
Because
my best.
he has difficulty.
Your Lordship, interim order be extended, Your Lordship.
It's still,
Actually, 3 months, it was there for 3 months, Your Lordship. It could not be extended in the last circuit
Or until further order, whichever is earlier is there.
because there was some personal difficulty of the learned.
yes, I
On the-
find that.
That is the reason why it could not be extended on the last circuit.
No, whichever is earlier.
Clear है, ये तो खत्म हो गया.
ठीक है, फोन क्या करेंगे?
So the dispute is only with regard to Govind Nagar village.
Yes.
Yes,
The remaining part is settled.
yes, yes.
3 months passed by in June.
19th June and 19th June
What?
circuit was there. In that circuit, Your Lordship,
I
it
find,
could
I've
not
seen
be.
this, I've seen this. So let this be extended for some time.
Yes,
Yes.
ma'am.
Since all the respondents have not been served, comma, let the matter stand over till 30th July 2025, paragraph. The interim order granted earlier is extended till let us extend it for till the end of August.
Yeah.
Till 31st August 2025 or until further orders, comma, whichever is reserved. Next.
That I am for the appellant. It should go to single bench for hearing.
It's not a second appeal, Lord. It's a first appeal against the trial court's judgment, because in view of an order being passed by a coordinate bench, that whether the first appeal would be laid before this court or before the district judge in view of the pecuniary jurisdiction, the matter is sub judice before the Honorable Supreme Court. They have taken out this appeal, certain interim protection was granted. It's not a second appeal. Had it been a second appeal, admission by the division bench, final hearing by the single judge. This has to be taken up by this court.
For the single bench.
No, this can't, it's not a second appeal. It's a
No,
first appeal under the.
Appellant only filed one similar matter.
No, no, no.
Single bench and
No.
granted stay.
No, it's not like that.
Yes.
No, this is a first appeal against the trial court's judgment. It's not a second appeal. Had it been a second appeal, I can understand. Admission under Order 41, Rule 11 by
Yes.
division bench, final hearing by the.
Single bench.
It's a
yes.
purely first appeal against the trial court. It can't go to the Honorable Single Judge, my Lord. It has to be decided by this court. I can place the relevant rule of the appellate sides. The Joint Civil Judge, Senior Division passed the judgment.
This issue has been dealt with by a coordinate bench, I find.
My Lord, this has to be heard out by this court only.
Should be placed before the single bench.
There is a special leave petition also in
It's
connection.
pending,
to-
yes, as
Yes.
regards the jurisdiction issue. Whether the first appeal would be laid before this court or before the district judge in terms of section 96.
So in that case, I don't think we can take up this matter for hearing now.
Yes, ma'am.
Till the matter is.
Yes,
dismissed by the Supreme
yes,
Court.
yes.
Similar matter, my Leonard friend only filed before the honorable single bench.
That issue has been decided by a coordinate bench on 8th April
Then in such,
2025.
all such matters should not be listed for hearing, my lord.
But
Yes.
let's go with this matter, my lord. Let's go with this
You
matter.
cannot blow hot and cold at the
Let
same
that
time.
be taken up.
If other matters come up, you are at
You
liberty.
cannot
to-
blow hot and cold at the same time. You want to eat ice cream as well as coffee.
What
It
my
is-
brother is saying, ice cream, coffee,
Sir,
before the
it is
honorable.
recorded, it is recorded in the earlier order that a special leave petition is tentatively returnable before the Supreme Court on 15th April. So this matter is still pending. Let the Honorable Supreme Court decide, we'll take up the issue after that. In view of pendency of special leave petition before the Honorable Supreme Court, as recorded in the order passed on April 8, 2025, comma, the matter be placed before the next available circuit bench.
When an interim order granted, that will continue till disposal.
Not till
Not
disposal.
till this.
I am ready, my lord.
31st
I am ready.
August.
Till this
The
Every
interim
time.
paragraph, the interim order granted earlier is extended till 31st August 2025 or until further orders, comma, whichever is it.
Mine. Okay.
Next. 10 and 11 are together.
Yes, sir.
So far as section 5 application, which has been taken out in 8 to second appeal has been served. I filed the evidence, sirs.
It's appearing.
The track reports, postal slips, everything is part of the affidavit of service.
Let me find.
The notice has been duly served.
This is-
Such a I appear before the trial court. No instruction so far. I would seek only 1 day accommodation. Let it be taken up tomorrow.
Very well. Yes, it has been served, I find. Yes, wait. Learned counsel for the respondents seeks accommodation. Let the matter appear under the same heading on 29th July 2020.
And extend your bill.
Next. So, sir.
Item 30 item 14, payment 18 of private enterprise.
My lord, I beg to appear, my lord, in this matter for the petitioner, but I think the respondent's advocate is not available, my lord. His junior, he had informed on my WhatsApp.
The direction. Next week,
Monday? Next Monday?
And whenever it's convenient to your lordships, my lord. it's not a-
Learned counsel for the respondents seeks accommodation. Paragraph, let the matter appear under the same heading on 4th August.
Item 15, payment 25.
No, they are from North and Middle Andaman district. We have served the notice. Lord, I have not received a track report. Let it be Friday, my lord, because if it is not, then I will direct the authorities to serve personally to the, and it can be taken up.
So in the meantime, you
Yes,
complete
yes.
service.
Friday, let it fix on Friday.
Since service upon the respondents is not complete, comma, let the matter stand over till 1st August.
Problem. 15 and 17 are
15
connected.
and 17, same one.
Item number 16, appeal of 25.
Just 1 day's accommodation and for the appellant. Let it
And
come
the
tomorrow.
official respondent.
Let it come tomorrow.
You're the respondent?
I'm
Official
first private
respondent.
respondent.
To official respondent.
Item
Learned counsel for the appellant seeks accommodation. Let the matter appear under the same heading on 29th July 2020.
Let.
Okay.
payment 8, sorry. Item number 18, payment 33 of 125.
Yes, who's appearing? None appears for the parties. No accommodation is sought. Let the matter appear under the same heading. On 30th July.
Item number 19, CRA TV 3 of 123, week grant 4 of 125.
Your lordship, this matter was practically disposed of.
What's
The
application
conviction-
about?
Conviction under POXO was affirmed by this honorable court. However, no compensation was awarded. That is why CRAN application has been made and
Have you served?
already served.
Where is your affidavit of service?
The date of service, I believe we have not filed it, your lordship. I'll be filing within a day or two.
Why didn't you serve the learned counsel here again?
I'm for the accused, I appealed for the accused last 2 years back, but now I have not received
No,
any
I
copy.
haven't served to him, to my learned brother. I have served it to the state
So
council.
since he is appearing, why don't you serve a copy to him? So he'll come to, I'll give you a day's time.
Lordship, compensation matter, to my understanding, he is not a necessary party. The compensation, state compensation is to be awarded and he's an accused, he has been affirmed.
Have you served the state?
I have served to the state. I'll file the affidavit to that effect. I'm not challenging anything, your lordship, except the part of compensation because neither the trial
It's
court
not
has
granted
granted,
at all. It was not granted.
it was
at
not
all.
granted, neither by the trial court or by the honorable division bench. And I have come up for modification of the order. So this matter has to be placed before the principal bench for placing it before the same honorable court, or it can be taken up by your lordship.
By the same, should be actually taken up by the same bench. And that's why I'm looking into who was.
Honorable Justice Devanshu Basant, I think.
Oh.
Devanshu Basant.
So without wasting time, let us pass an order to that effect.
Yes, yes.
Right? Let it be placed before the same bench. Since the petitioner / victim girl seeks modification of.
हम लोग कुछ करेंगे साले ऐसे ही डाल के रखे रिकॉर्ड में ऑर्डर लगाए ना कुछ
The judgment delivered on May 3, 2024, comma. The matter be placed before the Honorable Division Bench. Which has delivered the judgment.
Obliged.
Next.
I am appearing for respondent number 2 and 3, my lord.
Oh, okay. Please do it that way. If I-
Four.
Now we can see justice. Please do it that, please do it that. Thank you, yes. Yes, next one.
Item number 20, MAT 17 of 2024 with item number 21, MAT 72 of 2024.
Lord, I'm appealing to the respondent number 4, put by municipal council.
And for the private respondent. Your Lordship, in this particular matter, so this is Samantha sir is appearing behalf of the petitioner. I just read this matter can be fixed on 31st, he'll be before this honorable court physically.
He wants to come back on 31st, please do that. Learned counsel for the appellant seeks accommodation. Paragraph, let the matter appear under the same heading on 31st July 2020.
Obliged.
Next.
21 same matter. Item number 22, DRS 7 of 2021.
Yes, anyone appearing?
This matter yes for the.
Appellant?
Yes, my lord, I agree, and it will be not today and be placed tomorrow, my lord. Or it be passed
Have you
over, my lord.
sought?
My lord, I have no
You have,
instruction.
come back tomorrow then.
Yes.
Learned counsel for the appellant seeks accommodation, let the matter appear under the same heading on 30th, 29th July 2023. Tomorrow.
Grateful.
Item number 23.
23, my lords, I am appearing for the respondent, my lord. The petitioner is represented by Miss Nag, I think. This is for hearing, my lords. The matter is required to be.
File opposition.
Extension to file opposition.
I have strong objection, Your Lordship.
Because we could not able to prepare it. This are not departments.
No, no difficult. This paper book is to be filed. We can file paper book, my lord.
The opposition, specifically, they have sought for filing affidavit in opposition.
My lord may grant one peremptory extension, my lord. Otherwise, this matter requires to be heard. But since there is a direction, my lord may grant one opportunity, my lord. I think one peremptory extension may be granted, my lord, if it commends to your lordship.
Within a week?
My lord, 2 weeks, my lord, we grant.
Your Lordship, let it be within a week, Your Lordship. I have really very strong objection.
The earlier.
No, very well. Let it be within a week, but they will file their reply to it. So, my lord.
Let us see, Your Lordship. If
1
there-
week and 1 week.
I require only 3 days, Your Lordship. I don't require much time. Very short point is involved. I don't know how they.
No difficulty, no difficulty. My lord may grant us 1 week. Let them file the response to it.
Learned counsel for the respondents seeks extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition we file within a week from date. Affidavit in reply, comma, if any comma, we file within 3 days thereafter.
Your Lordship.
Within 3 days thereafter. So a week and 3 days takes us to almost the last.
7th.
8th. 8th August. Let the matter appear under this meeting on 8th August. Next.
Obliged.
Item number 24, review 2 of 23.
My lord, my lord, Mr. Kumar appears for the other side. I think they are seeking.
This is a review of whose order?
Oh, this is.
My lord, the honorable judges are not available, my lord. Both have retired, my lord. That is why, my lord, it is being taken up in the circuit bench, my lord. Justice Shubroto Talukdar and the second lordship is my lord Rabindranath Shamanto, if I'm not mistaken. We have filed our affidavit of compliance. There is a connected contempt proceedings. We have filed our affidavit of compliance because, my lord, the special leave petition has been dismissed by the Supreme Court. Although review is technically maintainable, but we have nonetheless filed our affidavit of compliance, my lord. What has happened, my lord, this concerns, according to us, this post does not exist. It is deemed abolished. But this person was a contractual person appointed against this post. The person contended that he has to be reappointed against that post. Now, we have given him all the benefits attached to the post. Only difference is, my lord, that different nomenclature is issued because according to us, the post is deemed abolished. And unless the post is revived, although this contention has been rejected by the division bench and we have preferred a review against the order, but, my lord, because hearing our submissions, my lord, the predecessor bench felt that since there is substantial compliance and no prejudice is caused to them merely because they are contractual, the person is a contractual worker, it's not a question of regularization. So a contractual worker is working against a particular post is their contention. We are saying that we have reappointed you, given you continuity, everything, which you're entitled to against that post, but we have used a different nomenclature because according to us, that post is deemed abolished. So the other side had to come back and respond whether they are satisfied with this or they still want to pursue the matter, my lord. That is what had happened on the last occasion. So, my lord, if Mr. Kumar is not there, my lord, it can be posted in the next week, my lord.
What is actually going through my mind is, the Honorable Chief Justice has designated a particular bench to take up review matters, contempt matters when both the judges are, or one of the judges is not available.
My lord.
We need to find out if the report will be general. Designated bench judge. So let us just find out whether
My
the
lord, my
is
lord.
applicable to the circuit benches also.
My lord, my lord, my lord.
Has to go back to that particular bench.
Absolutely, my lord, my lord.
Will you come back on Thursday?
My lord, whenever I am there, my lord.
I would let it be on Monday, madam.
Next Monday?
Next Monday.
She wants to come back on.
Ma'am, no difficulty.
Yes. Learned counsel for you for the respondents.
Respondents in review petition.
Learned counsel for the respondents seeks accommodation. Let the matter appear under the same heading on 4th August.
Blair.
Next.
Number 26, 55 of 123.
No one?
Very.
For the.
For the appellant bill.
And for the respondent, they file one application under order 41 rule 27. They file opposition to that. I'm serving copy to the.
Tomorrow, my lord.
This is again a first appeal. I think this
Family
issue is.
It's a family court. It's a family.
Family case.
Family court.
I'm just requesting tomorrow it will be taken. That's my further copy.
You file an opposition.
Yes, opposition against
Reply.
4127.
You want to come back with a reply?
It's that, quickly.
Can you do that in a day?
Will take time, I think.
Yes.
Time may be given. Some time may be given.
You wanted to come back tomorrow. That's why we are asking. Can you come
Reply
back?
not possible tomorrow. Every time.
Without the reply, we cannot take up the matter for you.
Let me check, then I will take tomorrow. Let me check the reply is required or not. Let me go through it.
Please do that.
Yeah.
Let us fix it tomorrow.
Yes, yes, yes.
If he doesn't want to come back with the reply, we can
Yes.
hear it out.
Yeah, yeah.
Affidavit in opposition filed by the respondent is taken on record. Paragraph on prayer of the parties, the matter is matter appear under the same heading on 29th July 2020.
Yeah.
Next.
Number 27, CRA DV 3 of 2024.
No one? None appears for the parties, no accommodation is sought, let the matter appear under the same heading on 29th July, 29th July 2023.
Number 28, Committee Award 3 of 2024.
My lord, I am appearing to the appellant. I seek extension of time to file supplementary paper book.
Some documents of arbitral proceeding is not there included in the paper book. I am for the respondent. And what are the documents I have already informed my learned friend?
I will
So,
collect it.
Next week,
My lord, let it be next week.
you come back next week,
My lord.
Monday.
No, my lord, Tuesday.
Learned counsel for the appellant seeks extension of time to use the supplementary paper book as sought. Paragraph, let the matter appear under the same heading on Tuesday's 5th August.
My lord,
Obliged.
oblige.
Next.
Petition number 29, Committee 5 of.
One coordinate bench says that pecuniary jurisdiction of district judge is up to 1,50,000. That matter is pending before apex court. Another coordinate bench says that district judge have jurisdiction. But now the matter is referred to the chief justice by the honorable other bench. Because contrary review is coming by two circuit bench. Supreme Court also pending that matter, and that is fixed. Today it was fixed. I am not aware what happened today. The SLP is pending before the Supreme Court in one matter. So my injunction order is already there, that may be extended, and let us wait up to SLP result.
Alternate counsels for the parties. Paragraph, this court is informed that the issue pertaining to the jurisdiction of the learned district judge as well as the division bench of the High Court in dealing with first appeals.
First appeals.
First appeals is pending before the Honorable Supreme Court. Paragraph, in view of the above, comma, the matter be placed before the next available circuit bench. Paragraph, the interim order granted earlier is extended till 31st August 2025 or until further orders, comma, whichever is earlier.
Right.
Next.
Party, seeks of.
Wait, please.
And. Item number 32. Here is 6 of 2024.
Lordship, I am for the straight lordship. It's appeal against conviction. Lordship, paper book is ready. I have received the paper book. Appeal lordship and Anukesh Sarkar. Learned counsel appearing for the.
Let it appear on Wednesday, day after.
Lordship. I will inform the defense counsel.
None appears for the appellant. No accommodation is sought. Paragraph, let the matter appear under the same heading on 30th July 2025.
Obliged, Lord.
Next.
Item number 33. Deputy Arun Award 7 of 2024.
Position, like the earlier, they have prepared the paper book and served upon me.
Appearing for the appellant.
We are
appearing for.
appellant, my lord. Let them, my lord, give us a list for some particular thing that we can ascertain those documents.
Entire arbitral, accepting the award, entire arbitral records.
So then, my lord,
The parties.
My lord, in that case, my lord, let them file it, my lord. They'll be able to let them file it, my lord. They can file the supplementary paperwork, my lord.
It is there.
Yes.
We can file it, my lord. May grant us 2 weeks, my lord. We'll file the supplementary paperwork.
2 weeks.
Anyway, there is no urgency, my lord, because in this matter, my lord, may I just submit? What has happened is, my lord, there was at the 34th stage, my lord, there was a direction to deposit 75% of the amount, and they were given the liberty to withdraw. So the amount was deposited and they have withdrawn it, and they have also furnished a bank guarantee. So technically they are secured, my lord. So my lord, kindly grant us 2 weeks time. We'll file, let them indicate whatever documents are missing, my lord. We will file those documents.
Learned counsel for the respondent submits that the paper book does not contain all the relevant documents.
The arbitrator, which was.
All the relevant documents pertaining to the arbitration. Paragraph, learned counsel for the appellant seeks to use a supplementary paper book annexing such documents. Learned counsel, please add, learned counsel, the first line of this. Learned counsel for the appellant seeks 2 weeks time to use a supplementary paper book. Please delete the first line. Annexing such documents. Paragraph, the matter be placed before the next available circuit bench.
Well,
Next.
Item number 34, Deputy 9 of 2024.
Lord,
And for the respondent.
Lord, we have filed an application for stay along with challenging the award passed by the under section 34 of the Arbitration Act. Here, the court has directed us to file a reply. Lord, just Friday it be fixed, my lord. In the meantime, if required, we will file. Otherwise, it can be heard out on bench. We have been.
An opposition is filed.
They have filed, my lord. We have been directed us to file a reply. We sought time to file reply. I just required, my lord, till Friday it be fixed, my lord. In the meantime, I will file my reply.
Right.
Friday.
Learned counsel for the appellant seeks extension of time to use a reply to the affidavit in opposition filed by the respondent. Paragraph, let the matter appear under the same heading on 1st August 2025. Next.
Item 35, WC 11 of 2024.
Lord, we have for the.
Lordship, I appear for
Andaman
respondent
Nicobar
number
district.
6 here.
I am appearing for NTPC.
Petitioner,
Petitioner is not appearing for the last so many days.
Let us see the file. One Mr. Mohammed Shahrukh was appearing for the petitioner.
Lordship, on the previous occasion, the petitioner appeared, Your Lordship. If I may clarify, on the previous date, respondent number 6 had filed an affidavit,
Yes,
which was directed by this court. For the same, the petitioner sought time to file a reply.
and today the petitioner is not there at all. Will you please inform the learned counsel?
We will inform, my lord.
Yes. None appears for the petitioner, no accommodation is sought.
Your Lordship, if I may, Your Lordship, in the previous occasion, it was not reflected in the order that we have filed the report, Your Lordship. We have filed the report,
There is that affidavit of opposition was filed.
but it was not filed by respondent number 6 because all the respondents have filed an affidavit. If it may be pleased, Your Lordship,
You are appearing for 6
yes, Your Lordship.
and you have not filed an affidavit.
We have filed. For the same, the petitioner sought time for it, for today.
Yes,
So it may be reflected that respondent number 6 had filed a report and the same has been circulated to petitioner as well as the other respondents. If it may be reflected in today's order, Your Lordship.
none appears for the petitioner, no accommodation is sought. An affidavit in opposition was used by the 6th respondent on the earlier occasion, comma, copy of which was made over to the petitioner as well as other respondents. The petitioner sought time to use a reply to the said affidavit. However, comma, he is not represented today. Paragraph, let the matter appear under the same heading on Thursday. Thursday?
Yes.
31st.
Obliged, Your Lordship.
31st June.
Obliged.
Next.
Item number 36, Document here 39 of 2024.
My lord, my senior appears for the petitioner, my lord. My lord, my humble submission to fix this matter to next week, my lord.
Next week,
Next week, my lord.
Tuesday.
Tuesday, my lord.
Anyone for the?
Yes, well, I'm appearing for the respondent. Ready to come on Tuesday.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 5th August. Next.
Item number 37, CRA Division of 2025.
Lordship, I am for the respondent, Lordship, straight. It's against conviction, Lordship.
Lordship, I am for the appellant, Lordship. Paper book has been served to the state and to me. For the victim, it has been not been served.
Is appearing for the victim. 5.
Actually, Lordship, this is a POXO case, Lordship, in which the victim will happens to be his wife of the appellant. So if it is served,
Victim happens to be?
his wife. If
They're under the same heading Inform the victim if you can,
Yes,
so
Lord.
that the matter can be heard.
Yes, Lord. Yes, Lord.
When did you come back? Friday?
Next week, Lordship, or next week, Monday or Tuesday, any day. In the meantime, we'll try because they are living in Maibanda, Lordship. It's a very, yes, Lord.
Fifth.
Grateful,
Fifth
Lord.
August.
Obliged.
Next.
Item 38. Repayability on of 2025.
My lord, I am appealing for the appellant. My lord, in this in this case, there is a application. They have filed an opposition. Today's time may be given to file reply. By Friday, I will come back for
What is
hearing.
the spot?
My
You are for the
lord, Lords, I am appearing for the respondent, my lord. Lords, may kindly appreciate one thing, my lord. This is an award passed in the year 2007, and the 34 application got dismissed only, my lord, 2 months back. Now, till the time the 34 petition was pending, my lord, the appellant never deposited the awarded amount before this honorable, before the executing court, my lord, or before the 34 court, my lord. And when he proceeded with the execution, my lord, now they have filed this appeal, where and till time, my lord, till date, my lord, they have not deposited it. So, my lord, this can, my lord, for staying of that award as well as the order, as well as the award passed, award and the order passed under section 34, my lord,
You used an affidavit in opposition, right?
that should not be stayed, my lord, till the deposit the awarded amount along with interest, my lord. That will be my,
Friday?
yes, my lord.
Please file your reply in the meantime. Please deposit the amount without prejudice.
Lordship, because I have already filed.
My lord, until unless
Yes.
then my stay application may be disposed of, my lord, by passing necessary directions.
The amount first. After that, consideration of any of your applications.
My lord,
By Friday.
They have filed the CAN application. We have given the remand.
yes.
Now this was hearing on.
No, yeah, we have to give reply. You have given opposition.
You have filed an affidavit in opposition to the CAN.
Yes.
They want to come back with a reply
Ma'am.
to that. All that is fine, but you need to deposit the amount.
My lord,
Yes.
They're only delaying, my lord.
no, we are not delaying, my lord.
Section 36,
Some time may be given, my lord, to deposit the amount.
sir. When was the award passed?
Upon has been filed, that,
7.
my lord, there was all along stay by the this honorable court till the disposal of the 34 petition, my lord.
So now 34 has been disposed of.
Yes, then we have come up with this appeal 37 within.
There is no further stay, you need to deposit the amount.
Yes, my lord.
Otherwise, this cannot be taken up for hearing, sir. When, how early can you, how soon can you deposit?
Lordship, with the
My lord.
ADJ code on before the honorable ADJ code, it is the 8th. So they have taken time there to deposit on the 8th of next month, on August.
8th of August, so
Yes,
let
that
this
order-
appear after that.
That order is there.
Please.
My lord.
Hmm.
In fact, they have given an undertaking to that effect, that,
No, no,
and the learned court below has specifically passed that order, that if they will not deposit by the next date, then appropriate orders will be passed so far as our petition filed in the execution case, my lord.
Hmm.
We have filed an application for attachment of the property and to initiate criminal contempt against the person who has filed a false and misleading affidavit in the court.
In this case, the Arbitration Act applicable is old Arbitration Act, my lord. Under that, there is a, once the appeal is filed, there is a stay, my lord. There is no condition required for deposit of the.
But that is, this submission is also.
Yeah, we have prayed for staying at the execution proceeding since the appeal is pending.
My lord,
If my lord pass any order in this case,
This is your submission before the executing court, the learned additional district judge. You've seen this
Madam, we are-
order, right? You've taken some time to
Madam,
deposit the
since
amount.
the appeal is pending before this honorable court, my lord, I pray that the matter may be taken up
This
by
could
this
be-
honorable court.
The next date is fixed on 8th August.
Yes, my lord.
Please deposit the amount before 8th August.
My lord, some protection may be given, my lord, by
No protection before that, please.
ma-
You are in fact playing with the court.
No,
I
my
can
lord.
assure you lordship that if the appellant,
My lord may pass any direction, my
my lord,
lord,
I
on
can assure you
to deposit. My lord, then,
Before
lord,
there is already an
my
order.
lord, I can assure you lordship.
Please deposit the amount by 8th. Only after that, this matter will be taken up here, not with.
my lord, this may be observed in this order, my lord, today's order, my lord, so that I can pursue it with the department, my lord. My lord, some direction may be given by the honorable court.
Learned counsels the parties. This court is informed that by an order passed on 9th July 2025 in money execution case 12 of 2019, the learned additional district judge has recorded as follows within inverted comma. Moreover, the learned counsel for the JDR submits that the department is under active consideration to deposit the awarded amount, possibly by the next date in the court itself, hence short accommodation is prayed for. Heard, stop. The court in such circumstances feels that if deposit of awarded amount is not effected by the next date, the next course of action will follow. Stop, inverted comma, closed. Paragraph in view of the above, let this matter appear under the same heading on 11th August 2025.
Grateful.
Please add a line to this. The appellant is directed to adhere to the undertaking given by him before the learned court.
My lord, that may be not recorded, my lord. I have not given an undertaking, my lord. My lord, it will.
Challenge that order, right?
My lord, there is no, it is not an undertaking, my lord, as well.
It is. Next
It is-
matter.
Act number 39. Yeah, 5 of 125.
For the respondent, state laws.
Lordship, I am for the appellant, Lordship.
Yes.
In this case, the appeal was admitted and the limitation was allowed by an order of.
Paper books are ready?
No, paper books are not ready, Your Honor.
Not ready? Trial court records are here? Foxo.
Yes, Your Honor. 10 years punishment, Lordship.
Section 5 and.
Heard learned counsels for the parties. Paper books are not ready. Paragraph, the matter be placed before the next available circuit bench. Next.
Welcome.
Item number 40, W 28 of 125.
Hello, my senior office with the petition.
When will you come?
Any day next week.
Tuesday.
Tuesday.
You are appearing for the respondent?
Yes, madam.
Tuesday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 5th August 2025.
Item number 40 on W 13 of 125.
Yes, petitioner.
Unless I'm appearing for the respondent one.
Anyone here for the petitioner? Yes.
In this last, on 11th of July, one order was passed. There's a direction to produce some modification to the response.
Yes, have you filed the relevant notification?
Have any other notification than what we have shown in the last circuit?
My lord, what has happened, my lord, in this case, if I may explain, my lord, here, my lord, the issue is that the petitioner is contending that the person who passed, instituted and carried out the disciplinary proceedings against him and held the appellate and was the appellate authority is not the disciplinary authority and the appellate authority in terms of the police manual. However, my lord, under Article 311 of the Constitution, my lord, there is a constitutional mandate that a disciplinary authority cannot be subordinate to the appointing authority. That is the constitutional mandate. Now, pursuant to court orders, my lords, in this case, the appointing authority is the Director General of Police. And the Director General of Police has acted as a disciplinary authority, and the appellate authority is the Lieutenant Governor, because appeals against the Director General of Police, the only other superior officer is the Lieutenant Governor. Now, they have raised the technical issue that in terms of the police manual, it was the Inspector General of Police who would be the disciplinary authority. Now, deholds the fact that we have last time also produced some documents to show that at the relevant point of time, the additional Director General of Police was given the powers of the Inspector General of Police, but deholds that point. Today, my lord, what the petitioner is actually calling upon the court or seeking a declaration is that the Inspector General of Police would be the disciplinary authority, because in terms of police manual is the disciplinary authority. But my lord, if the Inspector General of Police acted as a disciplinary authority, that would be contrary to Article 311 of the Constitution, because the person who the actual appointing authority in this case is the Director General of Police. With our affidavit opposition, we have annexed the appointment order, and that is not disputed. So, my lord, there was one instance I found before the Jharkhand High Court, that judgment is on record, where, my lord, the Jharkhand High Court has taken the view that where the appointing authority, actual appointing authority, is superior to the disciplinary authority in terms of the police manual, then the actual appointing authority has to act as a disciplinary authority. Because, my lord, the Constitution is superior to the police manual, my lord. So, therefore, my lord, in my humble submission, my lord, this is a technical point, my lord, which in any case, my lord, cannot be granted, because, my lord, if it is granted, it will result in violation of Article 311 of the Constitution, because they are not disputing.
Review, right?
My lord?
That's the ground taken in review.
Yes, but then the court permitted them to take that ground again when they giving them liberty to challenge both the original order and the review order, because this contention was not raised before the CAT at the first instance. So, my lord, my humble submission is, my lord, that this is not a legally tenable ground, because, my lord, the sequitur of what they are suggesting is that the Inspector General of Police will act as disciplinary authority over somebody who has been appointed by the Director General of Police, which, my lord, will be contrary to Article 311, my lord.
And my lord, one additional ground is that Inspector General of Police was disciplinary authority back prior to 2023. After 2023 new amendment, again the DGP has been inducted as the disciplinary proceeding. So now, if hypothetically this order goes, again, if the disciplinary proceeding will be carried out, then DGP only will be the person who will going to do the disciplinary proceeding. So there will be no change in the circumstances in today's date, due to the amendment of the police manual.
So you are not on merits of the proceeding at all?
No, my lord, I have made all my submissions, and the court asked them to produce the documents. Some documents.
So we have not heard your submissions. You need to make them all over again, right?
Today, it was only to produce the documents on behalf of them. So they are not producing the documents.
They say that they have no other document.
So it can be fixed for hearing. I will make appropriate submission at that point of time.
When will you come back?
Anytime, tomorrow, day after tomorrow.
Day after?
Day after, another matter is also fixed. Let it be on Thursday.
Thursday?
Thursday.
Well,
Learned counsel for the administration submits that the department does not intend to produce any further document / notification in support of their content, in support of its contention. Paragraph. The matter is otherwise ready for hearing. Let the matter appear under the same heading on
31st.
Thursday is 31st. 31st July 2025.
Grateful.
Next.
Number 42, 15 of 125.
Lordship, for the appellant, I create Thursday 26 paper book yet to be served from the respondent.
I'm appearing for official respondents.
Yes,
Thursday,
paperwork not served as yet?
not served.
Not sir.
Learned counsel for the appellant seeks accommodation. Let the matter appear under the same heading on 31st July 2025.
Obliged.
Item number 43 already fixed. Item number 44, WPCT 21 of 2025.
44, my lord, I am appearing for the petitioner, my lord. Mr. Shamanto was appearing for the respondent, my lord.
You'll be appearing physically on 31st, Your Honor. Item number 20 and 21 also matter is fixed for on 31st.
So come back on 31st.
No difficulty, whenever, my lord.
Learned counsel for the respondent seeks accommodation. Let the matter appear under the same heading on 31st July 2025.
Obliged, Your Honor.
Next.
Item number 45, WPCT 22 of 2025.
My lord, in item number 45, my senior appears.
Next week,
Next week,
Tuesday.
Tuesday. madam.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 6th May, 6th August, 5th August 2025.
My lord.
Item 46, MT 25 of 2025.
Senior appears on behalf of the respondents. I'm filing the paper.
When will you come back next week? You've served?
Monday, just now it has been served.
Tuesday? Paper books are filed. Let the matter appear under the same heading on 5th August 20.
Wednesday, my lord, the.
Very well, 6th August. 6th August.
Man, obliged.
Item 47 already fixed.
ঠিক আছে, ছেড়ে দিন যা আছে দেখছি। Yes, call the list, please. It will appear in the list. No, hearing it. Call the days, please.
There are individuals which are 195. For the respondent state law, she will bail application law. What happened? Argument and Dubai, that in one ever. Both have filed a bail application. One is here item number 1 and one is in post number 2 item. So, under counsel for the difference standing there, is from there. Yeah.
Very good, very good. So, not today? Let it appear tomorrow. Series there. By consent of the parties, let the matter appear under the same heading on 29th July. Next. Service not complete? When will you come back? Monday. Come back on Thursday? This Thursday? Friday? Since service upon the opposite party is not complete, comma, let the matter stand over till 4th August 2025. Next.
Item number 3.
Yes. You are appearing for the opposite party. Please serve learned counsel.
Yes.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 31st or 30th July. Next.
Number 4. That would be 325. System operating time. He has said that till the new telcos manifest, he will actually continue with it. Yes, continue. And he has submitted the final. He has issued the because of this, but the project sitting right on.
You are the petitioner. Have you? Yes. Yes.
I take time to take instruction. If a copy of the writ petition is given.
So please give him another copy so that he can take instructions.
My lord.
Thursday?
My lord.
Learned counsel for the opposite party seeks accommodation. Let the matter appear under the same heading on 30th July 2025.
My lord.
Next.
Yes.
Item number 5. Approve case 335 of 925. It's
in the other bench. Very well. Tomorrow, by consent of the parties, let the matter appear under the same heading on 29th July 2025. 5 and 6 both? Next.
number 7. 11/30/2025.
Yes.
But the vote act may not, 133, the public nuisance, ANS because they are still doing the, yes, part and all. In the, because I am in certain animals, which create nuisance. While passes and all, actually, actually vacated the house. But there was, there is no, the nuisance have been, out of that extent, very far. But yes.
He has passed a vacating order.
I vacated the, things that
Yes, are you ready for the hearing? Where is the impugned order? Please give me the books here. BNSS or BNS? The order impugned, certified copy. Who is appearing for the state? You're ready for the hearing? Yes, that's all your submission, right? You're the tenant. No, but the order says house belonging to Zafar Ahmed, the respondent.
I filed a suit for balancing, not, I was asleep. Then I was asleep, that the report was. I filed a suit. Now they are opposed to take something, said that I should be represented, that they will come from the nations. And then this disputing committee, and one.
Where is the application under 152 that was made? Yes, it's annexed.
It's not because I am not provided with the complaint.
This order pertains to the complaint, right? It's in response to the complaint. Do you have a copy of the complaint?
The thing is that order is not passed by the certified legislature, and the is a conditional order. And as per this conditional order, the opposite party had been called to show cause. And they have not appeared before the subject legislature to seek their meeting there. They have directly approached this object before and individual jury.
It may not be seen. That is not.
It amounts to show cause. It says that we have this month, we have to vacate the premises within 30 days from the date of receipt of the order. Complaints report must be submitted to the undersigned without fail.
After that, Your Lordship, further, if Srimati Munja Begum, wife of Azizur Rahman, Sri Vijayapuram, fails to comply with this order, she shall appear before the court of the undersigned at 11 AM on 7/7/25.
Yes,
Show cause.
the lady is challenging this. How the proprietor of the order.
Your Lordship, but they have not appeared before the.
Please come to 152. If an order is illegal, then she doesn't need to appear.
Your Lordship.
She can come before this court challenging the order, right?
Yes.
Please see 152. Conditional order for removal of nuisance.
Your Lordship.
So you have removed her, the lady herself, not the nuisance.
That point is understood, Your Lordship, with
Then-
regard to the. But Your Lordship, when.
The obstruction and nuisance was to be removed.
Your Lordship. Your Lordship. But if
So the order needs to be set aside. The magistrate will deal with the application in terms of 152
Yes,
upon hearing both the parties.
Your Lordship, that can be done if the magistrate.
Yes, yes.
Beyond the jurisdiction.
So what is enumerated?
To it, sir, you can understand that he has gone beyond jurisdiction, right?
But your Lordship, one more thing, this order has not yet been made absolute. This point can be raised before the magistrate. When she is appearing for show cause, because this order will be made absolute only when magistrate passes an order under section 160 of the.
Can the magistrate set aside his own order? Even if this is placed before the magistrate, can the magistrate revert the order?
Your Lordship, but this is a condition, this is not absolute.
No,
Because the trial has not commenced.
Maybe, but
If after.
Lord, it says,
the opposite
it says
party
I have to
makes
vacate.
difference,
every application under 152 does not require a trial,
Your Lordship.
right? It's
Somebody-
removal of nuisance.
Your Lordship.
So magistrate was within his powers to direct removal of nuisance.
Your Lordship.
Whatever nuisance it may be, because the application is not here.
Yeah.
He couldn't have directed the lady to vacate.
Yes.
Your Lordship, that is understood. Your Lordship.
So he has overstepped.
You know.
So let this order be set aside. Let both the parties appear. Let the magistrate deal with the application in terms of 152. Yes. Do you have anything to add, sir?
No, no, no.
Right?
That's
Third learned counsels for the parties. The petitioner is aggrieved by the order passed by the subdivisional magistrate, South Andamans on 5th June 2025 under section 152 of the BNSS, directing the petitioner to vacate the house belonging to the private opposite party without causing any sort of damage to the adjacent properties within 30 days from the date of receipt of the order. Paragraph. An application was filed before the subdivisional magistrate by the private respondent alleging nuisance caused in the property in question by the petitioner. In response thereto, the order impugned has been passed with a rider that if the petitioner failed to comply with the order, she would appear before the court and show cause as to why the order would not be made absolute. Paragraph. Section 152 of the BNSS deals with conditional order for removal of nuisance from any public place or any other place which may be lawfully used by the public. Stop. In the case in hand, the nuisance is in the house, right? The
premises.
nuisance alleged is in the house allegedly belonging to the private respondent. Upon consideration of the submission made on behalf of the parties as well as the order impugned, this court is of the view that the order is dehors the provision laid down under section 152 of the BNSS. Stop. The subdivisional magistrate had no authority to direct the petitioner to vacate the property in question in violation of section 152 of the BNSS. The subdivisional magistrate, having exceeded his authority in dealing with the application, comma, the order impugned dated 5th June 2025 is set aside. The subdivision paragraph, the subdivisional magistrate is directed to deal with the application filed by the private opposite party, private respondent, in terms of section 152 of the BNSS, upon granting reasonable opportunity of hearing to the parties. Stop. The revisional application being CRR such and such is accordingly allowed. There shall, however, be no order as to costs as in certified website copy.
Time frame, your lordship. The days in which the.
Time frames are actually cannot be granted by constitutional courts, you're aware. The Honorable Supreme Court has deprecated that.
Blair.
Please add, that line where I've stated that shall dispose of. Please repeat the line. No, prior to that. The comma, as expeditiously as possible.
Like.
Blair.
Next.
Item number 8. Serial certificate of 125.
In this matter, Mr. Tulsi Lal, the petitioner, is undergoing treatment in mainland Chennai.
So when can you come back? Next circuit? You are the petitioner?
Yes.
Learned counsel for the petitioner seeks accommodation on the medical ground of learned senior counsel. Paragraph, the matter be placed before the next available circuit bench.
Good.
Next.
Number 9.
My lord, this is a revision application by the state, my lord, because civil revision it has not been served. I checked it. Let me Friday, my lord, I have tried to serve the parties and it can be taken up.
Since service upon the
Parties.
opposite party is not complete, comma, let the matter stand over till
Friday.
Friday is 1st August.
Yes.
1st August. Next.
Item number 10. WPA 177 of 2025.
My lord, item number 10, I am appearing, my lord, a direction was given to file the affidavit. Affidavit is prepared. Let the matter may come up tomorrow. my lord.
Tomorrow?
Today.
Lord, let me
I
day
will
after
serve the-
tomorrow, let senior counsel will appear in this matter.
Very good.
Day after tomorrow. 10
Learned counsel for the petitioner seeks accommodation. Let
Right.
the matter appear under the same heading on 30th July 2025.
Up.
Next.
Item number 11. WPA 229 of 2025.
My senior appeal for the repetition. The respondents have filed the written affidavit in opposition.
You want to file a reply to that?
Lord, we have to seek extension of time to file.
You are not ready with your opposition.
Sorry.
1 week?
Yes.
Learned counsel for the respondent seeks extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within a week from date. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench. Next.
Item number 12, WPA 267/125.
Your Lordship, Ms. Bhavita Das is appearing for an official respondent, Your Lordship. I pray for extension of time for filing affidavit of opposition.
7 days.
Already 4 weeks.
7 more days, right? Please be ready by then. Learned counsel for the opposite party, respondent, learned counsel for the respondent seeks extension of time to use the affidavit in opposition as sought. Affidavit in opposition be filed within 7 days from date. Affidavit in reply, comma, if any, comma, be filed within 3 days thereafter. That takes us to 7 days is Monday. 8th August. Let us give it a try.
Okay.
8th August. Next.
Item number 13, WPA 290/125.
None appears for the parties. No accommodation is sought. The matter is adjourned. Please repeat these matters in the list tomorrow again. Next.
Item number 14.
Adjourned for the day.
No, it required reply, not because they are the DRM employees. They sought for reinstatement after a period of 5 years. This court directed us to file reply now. It is ready, not that week time be granted.
Expect my seniors appears on behalf of the petitioner.
You want to come back with an affidavit in opposition? Was there a direction already?
Yes.
Yes, sir.
Learned counsel for the respondent seeks extension of time to use the affidavit in opposition as sought. Paragraph. Affidavit in opposition be filed within 1 week from date. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. The matter be placed before the next available circuit bench.
Item 15 already said. Item 16, WPA 323/2025.
That I am appearing on behalf of the private respondent. Today I have filed my Vakalatnama in file.
Who is appearing for the petitioner?
However, I pray that 1 week time may be given to me for filing an affidavit in opposition. Mr. Balan appears for all the common officials. In the last occasion, he's appeared for 1, 2.
1 and 2.
1 and 3. 1 and 2.
What about 3? Have you served? You are appearing for 3?
Respond number 1 and 2, my lord.
1 and 2.
Yes.
Where is your affidavit of service for 3? There was a direction for service. Three is the private respondent, right? You are appearing for, oh, you are appearing for 3. So you want to come back with an affidavit in opposition?
Yes, ma'am.
Affidavit of service. Affidavit of service filed by the petitioner is taken on record. The private respondent seeks to use an affidavit in opposition in this matter. Affidavit in opposition be filed within a week, within 1 week from date. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench.
Obliged, my lord.
Next.
Item number 17, WPA 125.
So I am for the respondent number 2 and 3, Lordship.
What about 1?
Lordship, 1 administration.
1 is served.
Yes, sir.
Fine.
Whatever last direction upon me to file a report, Lordship, regarding some security upon one learned senior counsel of the bar.
Last order में कहीं किसी
Yes. So where is your report?
Lordship, I pray for 2 days, Lordship. On Friday, report.
Friday, you'll be ready with your report.
Lordship.
And please serve an advance copy
Lord.
so that they can see that. Learned counsel for the for the second and third respondents, your second 2 and 3, right?
2 and 3.
Seeks extension of time to submit the report as called for. Paragraph, let the matter appear under the same heading on 1st August.
Obliging.
Next.
Item number 18, WPA 84 of 2025.
What the plan for the petitioner? The stay is fixed for
Your
the
Lordship,
AO by
I am for the
the.
private respondent. I required 2 days time to file my AO. It's absolutely ready. My client could not come. He's from Hadley. He is reaching today. So just let it be fixed on Wednesday, Your Lordship, it will be.
The other respondent,
Other respondents are government respondents.
here have you served?
Officials.
Yeah, they're appealing.
Yeah.
1 to 4, yes, Mr. Mishra was here.
Yes.
You'll file your affidavit by Friday?
Yes, Your Lordship.
Then they need to come back with a reply in that case.
Your Lordship.
The private respondents seek extension of time, extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within 1st August.
Your Lordship.
Affidavit in reply, comma, if any, comma, be filed within 7 days thereafter. 7 days thereafter. Next circuit.
Your Lordship. Yeah.
The matter will place me for the next available circuit.
Even the official respondents, they are neither representing nor file the opposition.
Please add a line to that. Respondent numbers 1 to 4. Respondent number 1 to 4 are not represented. This should be the first one. Next.
Item number 19, WPA 285 of 135.
No one. None appears for the parties. No accommodation is sought. The matter is urgent for the day.
Item number 20 already fixed. Item number 21.
20 is fixed already on 4th, I find.
Item number 21, WPA 334.
21?
Item 21. Yes.
Yes. Have you served?
Not served.
Please give the file.
This is 1 day time. Is not affected.
The petitioner is directed to serve copy of the application along with annexure thereto upon the respondents and file affidavit of service on the adjourned date. Can you come back on Friday?
Hello.
Let the matter appear under the same heading on 1st August 2025. Next.
Item number 22, CRA on of 2025.
In connection with the CRAN application, my serial is A0 suffering for the petitioner. Let it be not today.
Yeah, for this state, I have referred an appeal for enhancement of the punishment. Under POCSO Act, 7 and 8, statute was filed, trial, then he was convicted and set up was given.
What is the application about?
For grant of compensation.
From the victim and compensation by the victim.
Under the Victim Compensation Act, right?
Let it be not today, Your Lordship.
Have you served the accused?
Yeah.
The accused? Where is your?
Accused is not the concerned party here, Lordship.
No, in the compensation matter, accused is not the concerned party, it's with the state. And your appeal is pending,
For enhancement of the punishment, I have served the court. I have served the court.
is it appearing in the list?
That.
Very well, let it appear, I'll find out. You want it tomorrow?
Yeah,
Learned Counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 29th July 2025.
Obliged.
Next.
Item number 23, CP2 of 2025.
So let it be day after tomorrow.
You are for the
Petitioner.
petitioner. Learned Counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 30th July 2025.
Item number 24, CPN 37 of 2024.
So I for the petitioner.
Contempt against whose order?
Attempt Honorable Justice Nizamuddin.
Oh, he has retired.
So your lordship can take up this matter.
Lord, let it be. Senior counsel, the Satadu Chakravarti is appearing, Lord. He will appear by online mode. Let be day after tomorrow it may be taken up.
He was there in the morning. He's not appearing.
Not there, Lord. Let it be day after tomorrow it will be taken up.
Do you want to use an exception to the affidavit of
I already
compliance?
filed. File wrong copy was given to me. I already filed exception.
No, that's the affidavit of compliance.
Yes,
You filed an exception to that.
yes, your lord, already filed.
When will you come back? Day after?
Day after. Your lord.
Please inform him.
Yes, yes.
None appears for the alleged contemners. You are appearing.
Along with Satadu, senior counsel.
Oh, very well, very well. On prayer of the alleged contemners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th July 2025. The copies are not in the file, please. The affidavit of compliance and the exception there. Next.
Item number 24, CPN 37 of 2024.
Lord, the order in question has been complied with. Whereas one rider was that it has to be removed by filing a corrigendum. The corrigendum is issued today. It has communicated to the party.
Let me be next Monday. By consent of the parties, let the matter appear under the same heading on Monday is 4th August.
Item
Next.
number 26, CPN 32 of 2025.
Here, I'm appearing for the petitioner members. This is order passed by the Justice Kaushik Chandra. On the last.
So it has to
circuit-
go before him.
No, last circuit, he was, justice was here. So he heard the matter and 2 weeks time was granted. So this has to be placed before the, this is Kaushik Chandra. But the last order says.
Where is the order under contempt?
So
That is his order.
It's a page.
Oh, it is his order, right?
13. Page 13.
Since the order under contempt has been passed by a coordinate bench of this court, the matter be placed before the Registrar General. Before the Honorable the Chief Justice, the Honorable the Chief Justice, High Court, Calcutta, for appropriate directions. Let it be only for appropriate directions. He'll do the needful. Next.
Item number 27. Year 3 of 2017.
I am for the appellant, my lord. This state serial. I pray for taking this next week, my lord.
Yes,
Next week, Monday.
sir, appeal, sir. Next week again, we not be able to complete.
My lord, we can take a chance, my lord. We can take a chance.
Yes,
We can take a chance next week,
Tuesday.
Tuesday, madam.
Learned counsel for the appellant seeks accommodation. Let the matter appear under the same heading on 5th August.
My lord. Okay.
Is it a short issue?
No, my lord, it's a big issue.
7 paper books are there.
7 paper books.
So if we start next Tuesday, how do we expect to complete?
Can be disposed of, madam. We can take a try.
Let's take a chance. Will. Next.
Item number 28.
This,
WPA 289 of 2020.
just not today, my lord. Not today.
The petitioner,
Yes, I am the petitioner.
day after. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 30th July 2025.
Number 29.
So I appear for the respondent union in this matter.
Mr. Lal is for the petitioner. Just have submitted his undergoing treatment.
Next circuit.
Next, sir. I am praying for that, sir.
Lordship, similar prayer was made on the last circuit also. Lordship, let the administration make some other arrangement.
Mr. Gowda, he is undergoing medical treatment.
Yes. That is my.
Learned counsel. We
No.
cannot stand in the way. It is submitted on behalf of, an adjournment is sought on behalf of learned counsel for the petitioner on his medical grounds. Paragraph, the matter is be placed before the next available circuit.
Good.
That's why our presence may be recorded.
Yes, yes.
Item number 30, WPA 270 of 20 all.
In item number 30, my senior appears for the petition. Thanks for next week.
Tuesday, Tuesday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 5th August 2025. Please be ready on the next edition. I am adjourning your matters. Next.
Item 30 all, PRR 27 of 2022.
My senior Mr. Rakesh is appearing for the petitioner members. TBI. I pray for next week.
I am the respondent.
Respondent. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 6th August.
Item 32, WPR 177 of 2022.
This Friday?
Yes.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 1st August 2025.
My lord, I appear for the private respondent in person. I appear. It's a very long pending matter, my lord. And the private respondent is temple committee. May I request to this,
I fixed it on this Friday.
my lord.
Please come back. Do you want to use an affidavit in this matter? No.
We'll find it.
Affidavits are ready.
It is directed, but this is a dispute between two private parties. And the Tahsildar has been directed to conduct an inquiry. And we have.
How is the writ maintainable if it is too private?
Civil suit is pending, my lord. I have already filed a civil suit.
Maybe,
status
but
for
what's
this.
the writ petition maintainable if it
This
is?
is the issue since 2022.
If it is between two private parties, how is the writ maintainable?
Because it is, temple committee used to, their allegation was they occupying their property. Their allegation is they are occupying.
That's a private dispute.
My lord. So for that, the temple committee has filed a civil suit and which is pending for adjudication.
Yes, how is the writ maintainable?
I'm the private respondent. I'm not the
Yes.
petitioner.
Very well, we'll come back on Friday.
Item number 33, WPA 276 of 2022, with item number 34.
Your Lordship, I am the petitioner in item number 34. The Union of India sought time to file their order.
I am appearing for the Union of India added respondent, my lord. I request learned senior to serve me a copy of the writ petition. I will file.
You don't have a copy of the
No.
petition?
I
It's
think.
appearing in 33.
Long ago. But
No.
Please give him
Yes.
another copy.
today itself, it
Who is in 33? The petitioner in 33?
The brace is considered.
Fine. Please give me 33 only.
actually, this is a very
33.
old matter.
Oh.
And if the copy of the writ application along with the elections was sent to the Union of India long before.
An extension was sought on the earlier date also for filing affidavit in opposition.
Yes, Your Lordship.
You are the added respondent,
Yes,
right?
my lord.
You sought an extension. You
Yes,
did
my
not
lord.
say that you don't have a copy.
Yeah, I have a copy of 33, my lord, but since it is tagged 34 also, I do not have 34 copy.
Please hand over a copy.
My lord.
You need another 7 days
My lord.
for the reply,
My
for the opposition?
Yes, my lord.
You are appearing for?
Union of India, Mr. Tulsila, item number 33.
You say you are for the Union of India.
Minister of Courts. There are two Union of India, I think. I am appearing. I am having. I don't know. ये देखो ठीक है रहने दो
You are for the port administration?
Yes, my lord.
And you are for the chief secretary?
No.
अவ்வளவுதான்
I think you are for.
And
My lord.
Kumar administration was represented by Mr. Shatabdi.
Yes.
And for others, Union of India, Mr. Shiv Balaji.
Added
I
respondent.
will not. But name is, that's why I'm asking that. My name has been mentioned in the clause. Okay.
ठीक है.
Learned counsel for the added respondent seeks extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within a week from date. Affidavit in reply, comma, if any, comma, be filed within a week. Within a week thereafter. The matter be placed before the next available circuit bench.
Oblige, my lord.
Next.
Item number 35, WPA 485 of 2003, brief at number 36.
But we are changing to Andaman Nicobar administration.
Petitioner,
Petitioner.
Tuesday,
Mr. Lalis from Union of India.
Tuesday. Learned counsel for the petitioner seeks accommodation. Let these matters appear under the same heading on 5th August 2025.
Okay.
Next.
Item 37, WPS 668 of 2003.
Solved? Affidavits are complete. Fine. So many matters in the next week, how will it be possible, madam? File the
ठीक है
affidavits.
I'm preparing for the respondent. क्या हुआ उसमें?
Here will not be private respondent, they have filed everything, reply is ready. But the official respondent from the, from 2023, they have not yet filed.
Filed it.
Filed it.
Okay, one.
Have you filed your reply?
Yes, my lord, everything is ready, madam. Ready, madam.
Reply filings, petition. You filed a composite reply for both?
Yes, madam. Yes, madam.
Active reply, petition. Good, right? Monday? Learned counsel for the petitioner seeks accommodation. Let these matters appear under the. Oh, you're the private, I'm so sorry. Learned counsel for the private respondent seeks accommodation. Let these matters appear under the same heading on 4th August.
Oblige, Your Honor.
Next.
Hmm.
37 and 38 are.
38 separate.
Item number 38, WPA 912 of 2023.
Private respondent.
I'm for 124. Respondent number 124.
Petitioner, you are the petitioner.
Tomorrow. This matter is tomorrow.
Tomorrow. Are you ready with the reply? You are supposed to come back with a reply. And the last chance was,
Again, they are playing this.
last chance has already been granted.
Tomorrow.
Tomorrow you'll be ready with your reply? Have you served? Yes, for that reason, several opportunities were granted to you. When will you serve if I fix it tomorrow?
Let it come tomorrow. If not, this matter can be taken up for hearing.
Very well.
Madam.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 29th July 2025. Tomorrow.
If it is day after tomorrow, it will be better, probably.
Very well. 30th,
Very well.
30th July.
Oblige.
My lord, extremely sorry to mention, my lord. I am Anil Gupta, my lord. One matter, 28 number item was, my lord. I missed the list, my lord. 28. I am a 28, 28.
An order has been passed. Please give me a minute.
Day after tomorrow.
28, day after. It's fixed day after tomorrow.
All
30th.
right, sir.
30th.
All right, sir.
Yes, 39. Why can't this matter be placed for mediation? Yes? The petitioner is not there today. So the application has to be filed by the petitioner, right? You say that one of the petitioners has a. So you filed an application for substitution. That has been incorporated, right? That was not done? And so please think over it if it can be sent for mediation. Learned counsel for the appellant seeks accommodation. Let the matter appear under the same heading on Friday, 1st August 2025. Next. Yes, ready? You'll be ready tomorrow? Very well. By consent of the parties, let the matter appear under the same heading on 29th July 2025. Next.
Number 40 on, there are 23 and 24.
What are the matters about? Yes? So you can come back tomorrow? Day after. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 30th July 2024. 41 to 44.
Your Lordship.
Same order. This arises out of the same FIR.
Your Lordship.
They are different petitioners.
Your Lordship. All are son and father and son, mother,
Oh,
like that.
related.
Your Lordship.
Next.
45, WPN 90 of 2024.
Appearing for the respondent.
Senior affairs with petitioner. We're praying for next week.
Monday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 4th August 2025.
Item 46, WPN people of 2024.
Your Lordship, Mohammed Tabriz sir is approved behalf of the private respondent.
1, 2, and 3.
Yes. Yes, when do you want to come back? Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 30th July 2025. Day after.
Item number 47, WPA 207 of 2024.
Yes.
My lord, in this matter, item number 47 and 51, similar matter, my lord. This is against an allotment of BBMC shop, my lord. What I say, my lord, let this matter be appear tomorrow.
Your Lordship, I am for the petitioner. Similar matter has already been disposed of. Orders have been passed, but challenging that order, they preferred an appeal. Appeal was dismissed. They got liberty to file a review application before the same judge. They filed the review application, review was also dismissed. They said that they are trying.
This is in respect of other petitioners.
Other
right?
petitioners, but issue is the same.
Standing on the same footing.
Yes, yes, yes. This is relating to the allotment of the shop in the Port Blair municipal area. Now, Your Lordship, they said that they are thinking of preferring an appeal before the appellate court, before this honor, division bench of this honorable court. But till today, no appeal has been filed, and these matters are just adjourned, Your Lordship, from time to time. Only on that basis.
Let it fix on Thursday, my lord. I take instruction, otherwise it can be heard out on merits.
If the similar issue has been decided, then let there be an order on the same line.
Go through the records, my lord.
If you are on appeal, you can go for appeal of against all these orders together.
I'll take instruction, but I come back on Thursday.
Day after?
Thursday, let it be not, day after, there are a lot of matters.
Day
Wednesday,
after,
madam.
Thursday you want to
Thursday.
come back? So by consent, I'll fix that. By consent of the parties, comma, let the matter appear under the same heading on Thursdays, 31st July 2025.
Your Lordship, 47 and 51. Both the matters are.
Same order in 47 and 51. Yes. Next.
Item number 48, WPA 224 of 2024.
Monday, next Monday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 4th August 2025.
Item number 49, WPA 30 of 2024 with item number 50.
Your Lordship, I am for the petitioners, Your Lordship. Let it be not today, Your Lordship. Tomorrow.
Let it be on Thursday, Manoj. Close the day.
You are appearing
Yes, ma'am.
Thursday.
Thursday.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 31st July 2025.
Item number 52, WPA 405 of 2024.
Yeah, my lord, from August 2024, it is pending for affidavit in opposition.
Who is
Now-
appearing?
Lord, I
This is
checked
the
the
background.
records.
The respondents?
Lord,
You are appearing.
for the respondents.
Where is your affidavit in opposition?
Lord, I check the records. Let it be not today, will I take instruction, but it is ready, because if you change of the,
Going to pass 1 year.
Lord, if it
We are
is
at
not
again.
filed, I pray for a parametric last chance we granted, I'll file it.
My lord, I think they have filed it or not. I have not received the copy.
On prayer of
You
the
can check, my lord, there are-
respondent,
let it come tomorrow.
comma,
So that-
the matter is adjourned for the day.
Yes.
Transfer of officer concern and all that, please, you have taken already.
Everything over.
So
Everything
please
over.
look into it.
Yes.
Next. You are respondent number 4. There is an affidavit in opposition by respondent number 4. 4 people.
My lord, all the respondents, my lord. All the respondents. Altogether 5 respondents, my lord.
Who is 4?
4 is settlement officer, my lord.
Settlement officer has only filed, the others have not filed.
Lord, on behalf of others, they have filed. But I have not received the copy, my lord.
No, this is only by the settlement officer.
And I have not received the copy, my lord.
On behalf of the respondents. So it is there on
Yes, yes,
record.
But the
Please
copy
give
has
her a
to be
copy.
given.
Lord, I just,
Lord,
Lord, but then fix it for hearing on Thursday, I will give a copy
He
today.
needs to come back with a reply.
Reply within 3 days, my lord.
Let it be 3 days after 3
If they
days.
give.
I
then
just,
Let's change the order.
can we
Affidavit in
schedule for-
opposition filed by the respondents is on record. On prayer of the petitioner, liberty is granted to use a reply to the said affidavit within
Thursday, I'll file it.
31st?
Yes, my lord.
Within 31st July 2025. Paragraph, let the matter appear under the same heading on 4th August 2025. Copy those.
copy the file.
Item number 50, WPA 407 of 2024.
Petitioner. That's no cannot. That's the issue. Withdraw. Withdraw and go before the appropriate forum. He is not in a position to make his submission. Very well. Wednesday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 30th July. Next. Yes, anyone appearing? Affidavit in opposition.
They have not paid the salary.
Why do you require an affidavit in opposition?
1 year has passed, dear lordship, the filing the case.
They're not even filing the office.
Yes,
Lord, it has been already sent for vetting, Lord. 2-3 days it is filed. Let it be fixed in Friday, my Lord, I give.
Friday.
advance, Lord.
Dear lordship.
learned counsel for the respondents seeks further extension of time for filing the affidavit in opposition as sought. Paragraph, let the matter appear under the same heading on 1st August 2025.
Yes.
Next.
Item number 55, WPS 652 of 2022.
My senior appears for the petitioner. Direction was there upon the respondents to file opposition.
Lord, here I seek for a fixed
Fine.
time. So,
Further extension,
Lord, as not the last chance to grant it.
an extension was already granted. Affidavit, learned counsel for the respondents seeks further extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within 1 week from date. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench. Next.
Item number 56, WPS 654.
Lord, I'm appearing for respondent number 2, my Lord.
I am appearing for respondent number 2. Of other respondent.
Petitioner. Adjourned for the day.
Yes.
None appears for the
My Lord, I am
petitioner.
seeking extension of time, my Lord. Further extension of time. Respondent number 2. Yes, my Lord.
Fine.
Other administration, secretary law.
None appears for the petitioner. No accommodation is sought. Paragraph, learned counsel for the respondents seeks further extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within a week from date.
My Lord.
Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench.
Obliged, my Lord.
Next.
Item 57 already fixed. Item 58, WPS 730 of 2022.
Let it not today, my Lord. We'll take it up tomorrow.
Your lordship, I am for the petition.
Not today.
Short point of interest.
Tomorrow.
Yes, your lordship.
On prayer of the respondents, the matter, comma, the matter is adjourned for the day.
Item number 59, 84 of 2025.
I appear for the respondent, dear lordship.
Petitioner. Petitioner. Tomorrow, on prayer of the petitioner, the matter is adjourned for the day.
Item 60, CRR 6 of 2025.
No one? None appears for the parties. The matter is adjourned for the day.
Item number 61, WPA 110 of 2025.
I appear for the respondent.
Petitioner.
It's time to file reply. So next week.
Who's the reply?
7 days.
Third.
Reply. Learned counsel for the petitioner seeks.
I've already filed my opposition, whether it has come to the record, my lord, I have filed before the department. Before the.
Has the opposition come?
Written opposition, the other is-
I haven't received any copy.
Please, sir.
I have already served the petition.
You serve the other respondents also.
One respondent. Give me one copy, please.
You to serve all of them. You are 1, 2, and 4.
Fine.
Fine. Or 3 has also filed a separate affidavit.
I have
in
filed, I
opposition.
have already filed.
So you've received both,
Yes, yes.
and you'll file a composite reply to both of them.
I have filed my opposition, it is not recorded, my lord,
I
since-
have not received the.
Please serve him a copy.
I already served to him long ago.
You've not received copy of which affidavit in opposition?
Filed by respondent number 3.
I've already served. I can show the.
Madam, please serve him an additional
I'll-
copy. He has
additional, I'll-
misplaced it, must be. You need 7 more days? Learned counsel for the petitioner seeks extension of time to use the affidavit in reply as sought. Paragraph affidavit in reply be filed within 7 days from date. Paragraph let the matter appear under the same heading on Wednesday, 6th August.
Number 1, 2, and 4 have filed their opposition.
That's already on record. Because he asked for a reply on the earlier date also.
Since I have filed.
It's on record. Because he's asking for time to submit a reply.
That shows.
Yes, it's. Praise for extension of time to file affidavit in opposition. Please add a line in at the beginning. Affidavits in opposition used by the respondents are on record. Next.
Item 62, WPF 49/2025.
Similar order can be passed.
You've also filed your.
Yes, I also filed.
You want to come back with a reply, so the same order, same order. Next.
Item 63, WPF 20/2025.
63, anyone? None appears for the parties, the matter is adjourned for the day.
Lordship, 63, Lordship, for the respondent, Your Lordship. Lordship, the affidavit in opposition is ready, Your Lordship. It is being affirmed today. I need 4 more days time, Your Lordship, to get it. Lordship,
In advance, you're not visible.
Lordship, my video is on, Your Lordship, now.
So you will be coming back on Friday with your affidavit?
Lordship, kindly fix it on Monday, Your Lordship. Friday I have difficulty, Your Lordship.
For the respondents, none appears for the petitioner. Stop, no accommodation is sought. Paragraph, learned counsel for the respondents seeks further extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within a week from date.
Yes, Your Lordship.
Within a week from date. Affidavit in reply, comma, if any comma be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench. Petitioner is not interested. Next, 64.
May it please, Lordship. The 64 is an application for quashing. Very interesting sort of case. There are certain offenses relating to entering the Jaroa area and taking photographs or videos. Now, this particular person is a person who makes documentaries. The allegation is that sometime in the 80s, the then Lieutenant Governor, accompanied with police officers and staff.
Who is appearing for the state?
So the state, Mr. Kormokar is there, but the complainant is an officer from here who has now been transferred. Now, what has happened is there was an interim order granted and I was directed to serve. But thereafter, my lord said, since these photographs are in your petition also, to take it back and redact it. But by then the service had gone by post. So then a further order was passed to give them a notice. Then when they come and appear, if necessary, that portion has to be removed from their petition. No matter, as of now, they have not appeared. The state has appeared, and in the state's presence, the interim order was passed. My humble prayer was the interim order in the last circuit was expiring, but it came up before my Lord Justice Rao could not hear the matter for personal reasons. The matter could not be listed in the either of the other benches. So the humble submission at this stage would be, my Lord, the interim order may be extended and let them appear as and when they come. Thereafter, the matter has to be heard out on minutes. The problem is because the petition, Your Lordship will see those photographs are there. But these are again recorded by my Lord Justice.
Where is the last extension of the interim order by Justice Sengupta?
Justice Sengupta granted the interim order. It has not been extended thereafter. The next circuit with my Lord Justice Rao.
Where is the order grant? I do not find that interim order was granted. Where is that?
Interim order was granted.
When was the interim order granted?
Just Honorable, if I see the order dated June 10th, 2025.
Oh, for a period of 5 weeks.
My lord.
So that is over, right?
But that was expiring on the 15th, if we have to take it as 5 weeks. But thereafter, the matter was placed before my lord Justice Rao. His lordship was not inclined to take up the matter. So his lordship had said, go to the other bench. The other bench also, the matter was not listed. Now, in the meantime, it has expired. So this is the immediately next bench, my lord, after Justice Rao's bench. So on the first day itself, my lord, I wanted to make the submission.
No one for the state today.
Mr. Kormukar is appearing in this matter.
Where is he?
Because the order was initially passed in his presence after hearing him as well.
Let me fix a date. None appears for the state. Let the matter appear under the same heading on, when will you come back, Friday?
Whenever you're lordship.
On 1st August 2025, please inform him. If you can. The interim order granted earlier shall be extended till 31st August 2025 or until further orders, comma, whichever is early. Next.
Item number 65, WPA 53 of 925.
My lord, my senior appears for the petition. I'm seeking extension of time to file reply, madam. Let it be in the next week, we'll file.
The learned counsel for the petitioner seeks extension of time to use the affidavit in reply as sought. Paragraph, affidavit in reply be filed within a week from date. Paragraph, let the matter appear under the same heading on
Wednesday.
6th August. Next.
Item number 66, WPA 78 of 925.
66, my senior appears for the petitioner. There was a direction upon the respondents. to
I pay
file.
for respondent number 2 and 5.
1
2 and 5, I seek extension of time.
Yes. 1 to, sir.
2 and 5. 2 and 5, I seek extension, my lord.
Pertains to not the legal.
What is the 215? It's item, it's 78 of 2025, right? You also want to come back with an affidavit in opposition? You are not ready with it? 7 more days.
2 and 5, my lord. I'm appealing for 2 and 5.
Ah.
I'm appealing for 1, 3
What is
and
that?
4, my lord. We have filed, my lord. 1, 3 and 4 has filed the letter.
1, 3 and 4 have filed.
Yes, my lord.
2 and 5
1,
praying.
3 and 4, so 2 and 5 and 6.
Yes, my lord.
Affidavit in opposition filed on behalf of respondent numbers 1, 3 and 4 is on record. Paragraph, respondent numbers 2, 5 and 6 seek further extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within 7 days from date. Paragraph, affidavit in reply, comma, if any, comma, be filed within a week thereafter. Reply within a week.
My lord.
Paragraph, the matter be placed before the next available circuit bench.
Obliged, madam.
Next.
Item number 67, WPA 106 of 925.
I should ask for the private response.
I seek
My
time to
senior appears
file.
for the petitioner. Here also my.
I seek extension, my lord. 1 to 5, I seek extension, my lord.
You don't want to come back with an affidavit in opposition?
Already filed.
Already
You
filed.
have filed.
Already filed.
Fine. And you are for 1 to 5?
Yes, my lord.
Affidavit in opposition used by the 6th respondent is taken on record. Paragraph, respondent numbers 1 to 5 seek further extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within 7 days.
7 days, my lord.
From date, stop affidavit in reply, comma, if any, comma, be filed within a week thereafter.
My lord.
Next circuit.
Obliged, madam.
The matter placed before the next circuit. Next.
Item number 68, WPA 119 of 725.
Yes.
Order passed by this court appointing a special officer to hold local inspection on 2nd of August 2025 is under challenge before the division bench.
2nd of August 20.
Yes, this date was notified by a single judge. No, that order is coming, it has been challenged. The appeal is coming up tomorrow day after.
Fine.
The order dated 8 July 2025 may kindly be seen. This order is under challenge.
You are the petitioner?
I'm
here?
the petitioner.
I've already filed my opposition. We could not record the order sheet that I have filed my opposition.
I'll record that. It is said that the order is appealable under regulation 28(1)(a).
Only passed by the vessel.
The impugned order.
The impugned order.
Yes, ma'am. This order dated 8 July 2025 has been assailed in an intra-court appeal. It's coming up tomorrow, dates under.
Order.
No, I have challenged this order, not order of the single judge. This is in a, this would be before my lord only.
So on both the aspects.
No, only,
The last order.
only,
No, you have challenged this order.
Yes.
Only on the ground of appointment or the maintainability issue
and
also?
both.
Where-
Both. आता है कल या परसों आएगा नहीं आज ही फाइल होगी नहीं कहा है बुक का सेकंड अगस्त है टाइम है
Learned counsel for the petitioner submits that the order passed by this court on July 8, 2025 has been assailed before the Honorable Division Bench of this court. Paragraph in view of the above, comma, the matter is adjourned. Before that, affidavit in opposition submitted on behalf of the respondents is taken on record.
obliged
No, is adjourned, that's all. Because the appeal has to be disposed of first. No date is fixed for this. Just matter is adjourned. They'll mention after. Next.
Number 69. WPA 132 of
Your Lordship, I am for the petitioner. They
I
have
am
to
for-
file
I
opposition.
seek extension, my lord, to file opposition. Last chance.
Long pending matter.
One
No,
circuit is going like this unnecessarily. Should have been ready by now, sir. Fine. Learned counsel for the respondents seeks extension of time to use the affidavit in opposition as sought. Paragraph affidavit in opposition be filed within a week.
Within a week.
Within a week from date. Affidavit in reply, comma, if any, comma, be filed within a week thereafter.
Directions peremptory.
Obliged.
Peremptory direction.
This is the first extension that they're asking.
Yes, ma'am.
The matter be placed before the next available circuit.
इसका भी डबल की कॉपी इनको भेज देना
No, 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 no.
नहीं
WPA 196 of 2025.
I appear for official respondent, my lord. I seek extension to file opposition.
Private respondent already filed opposition.
Sir, you're not ready in any of the matters.
This is my last matter, my lord.
That's a good submission. Learned counsel for the file, please. 70. You are for 5, respondent number 5.
my lord.
Learned counsel for respondent number 5 seeks further extension of time to use the affidavit in opposition as sought. You filed an affidavit in opposition already.
That's of us, fine.
You are for
Official respond, my lord.
respondent number?
I see. One, like, phone, copy. I didn't have the
Ms. Nag is for the petitioner.
Anand Haldar is there for this.
Private, that is, five is the private respondent. Oh, she's with you.
Yes.
I thought she was making a separate submission. So 1, 2, 4.
My lord.
1, 2, and 3 have already filed.
My lord. Was filed.
Copy of the opposition is already served upon upon the petitioner. You've received the copy filed by one.
For the respondent. Oh, petitioner is not represented today. And for the respondent, private respondent.
You have already filed an affidavit in opposition.
My lord.
1, 2, and 3. There is no other affidavit in opposition, only this. Affidavit in opposition filed by the 5th respondent is taken on record. None appears for the petitioner.
आपको कॉपी है क्या? One.
For 1 and 2. The petitioner has submitted a reply against 1 and 2's affidavit. And you say that you have not filed.
My lord, I will check up.
1
I'll
and 2
check
has
the
been
record.
filed in opposition, but I find the reply here.
I will check the record. Maybe 5, 6 over.
Affidavit in opposition filed on behalf of respondent number 5 and affidavit in reply filed on behalf of the petitioner to the affidavit in opposition filed by respondent numbers 1 and 2 are taken on record. However, 1, 2, and 5 affidavits in reply. However, affidavit in opposition used by respondent numbers 1 and 2 is not on record. Paragraph learned counsel for respondent numbers 1 to 3 seeks to take instructions in this regard.
My lord.
Paragraph, let the matter next week.
My lord.
Let the matter appear under the same heading on, I've stated that petitioner is not represented. Please, first line. Next Monday,
My lord.
4th August. Next.
Number 71, WPA 209 of front and
For private respondent, I have already filed out the same for the petitioner.
seeking implementation of the demolition of since they use their opposition. Being accommodation will be given to use our reply. Monday, this matter can be.
I'll fix it up on Monday. Please use your reply by then, right? Affidavit in opposition is already on record.
It's already filed by opposition.
Yes.
Private respondent.
Affidavit in opposition filed by the private respondent is taken on record. Learned counsel for the petitioner seeks accommodation to use a reply to the said affidavit paragraph. Let the matter appear under the same heading on 4th August. Next.
Item number 72, WPA 221 of 2025.
Item number 72, my senior appears for the petition. I'm seeking
Lord, we
extension
file our-
of time.
We
to
file
file
our
reply.
affidavit in opposition.
Extension to file the reply.
Right. 1 week time may be given. By next week we'll file.
You'll come back by Monday?
Monday.
We'll be ready on Monday.
My lord.
Affidavit in opposition filed by the respondent is taken on record.
एक उधर है
Learned counsel for the
एक उधर
petitioner
है।
seeks extension of time to use a reply to the said affidavit. Reply be filed within a week from date, paragraph, let the matter appear under the same heading on 5th August, Tuesday. Please serve a copy by Monday. Next.
Item number 73.
75.
Speaks for court directed respondent to file their affidavit in opposition.
File. Yes, your opposition.
This is Babita.
My lord, strongly appearing the list, my lord, Mr. Shiva Balan is appearing on behalf of the respondent.
Yes, his name is in the order sheet.
Yes, my lord, but my name is strongly appearing in the cause list.
It will be corrected. Please do the necessary corrections. Where is the affidavit in opposition? Mr. Shiva Balan. He was here. Where is he?
Not today, there are. Not today. But let it be not today, my lord.
None appears for the respondents. The matter is urgent for the day. Please inform him.
Yes, yes.
Next. Petitioner.
My lord, I am saying about the private respondent.
What about the petitioner?
My lord, I may be directed to, I have been directed to file an opposition. If it's on Monday, I will be filing.
Anyone for the petitioner? You'll file within a week? None appears for the petitioner, no accommodation is sought. Paragraph, learned counsel for you, the private respondent. Learned counsel for the private respondent seeks a week's accommodation to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within a week from date. A very short matter.
Yes, it is not maintainable also. Or expectation. The point is that in some paragraph, we have.
Will you please inform the petitioner so that I can take it up on next week? Yes. Please don't write that line within a week. No, 6 accommodate. To use the affidavit in opposition as sought. Paragraph, let the matter appear under the same heading next Monday on 4th August 2025. Please inform the petitioner. Next.
Lord, I'm sorry, but yeah, I seek extension of time to file my reply, my lord. This is, I'm sorry. Let it be.
Only you have sought extension, nothing else.
I'm sorry, my lord.
Fine. Let counsel for the respondent seeks extension of time to use the affidavit in opposition as sought. Affidavit in opposition be filed within 7 days.
Yes, ma'am.
From date, stop affidavit and reply, comma, if any comma, be filed within a week thereafter. The matter be placed before the next available circuit bench.
Obliged.